All right, this morning we are going to begin with an admission ceremony. Carol P. Smith, Bar Admissions Administrator, will be presenting 2 individuals for admission to the practice of law in the state of West Virginia.
Good morning.
Good morning. May it please the court, Carol Smith. I am the Bar Admissions Administrator for the state of West Virginia. I appear before the court today for the purpose of moving the admission of 2 new lawyers into West Virginia. Timothy Andrew Joseph Dunning is a successful applicant of the West Virginia Bar. He's being admitted under Rule 3.0. And Jessica May Sanchez-Vestal is applying for admission under Rule 3.5 of a transferred uniform bar exam. She took the bar exam in Tennessee. We have completed a review of the applications, and we have done all the necessary investigation, and I represent to the court that each of these candidates has satisfied all of the requirements to practice law in the state of West Virginia. As such, I move the admission of Timothy Andrew Joseph Dunning and Jessica May Sanchez-Vestal at this time.
Well, thank you very much, and to each of you, welcome. We are honored to approve your motion for your admission to the West Virginia Bar. If our clerk would administer the oath.
All right, if you would both please raise your right hand. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the state of West Virginia. I will honestly demean myself in the practice of law and to the best of my ability execute my office of attorney at law, so help me God. Congratulations.
Yes.
Thank you.
Well, again, good morning. We've got a couple of minutes before our docket, so you're going to have to pay the price. In all seriousness, we are excited about this day. This is a big day for each of you, and it's a big day for us here at the court. Typically, the room is full because on a normal bar admission, we have a number of people, and to your credit, Timothy, you said, you would like to do it in person. So yes. This worked out very well. Do you have a loved one with you that you'd like to introduce?
No, it's just me today.
Well, it's okay, good. I saw somebody, it's like a wedding, bride and groom, and which side of the...
They're watching online.
Well, that's terrific. Well, step up to the mic, make sure you, that's where the best, tell us about where you went to law school and what your practice plans are.
Sure, so I went to the University of Baltimore. I actually graduated in the spring of 17. I've been practicing in the state of Maryland for going 3 years now, in the Deep Creek area, Garrett County, which is borders, West Virginia. So we have a lot of work that bleeds over into West Virginia, so I decided to take the bar a second time in my life, and pleased I passed.
Well, congratulations.
Thank you.
Welcome to the beautiful West Virginia Supreme Court chamber, and we wish you very well. I'll introduce Jessica real quick. Welcome as well. Please step up so anybody watching at home, understand you have located to at least the Huntington area with your husband, and as a Huntingtonian, let me welcome you to Cabell County in West Virginia, and best of luck during the upcoming legislative session. The Senate will be a busy place, and I'm sure you will be a very busy lady.
Yes, I'm already very busy, and I just started.
And you hail from Tennessee, I understand?
Yes. Well, I'm originally from California, but I did undergrad and law school at Belmont in Nashville, so I spent the last 8 years there.
Well, good. Now, let's see. Marshall Football is your husband?
Well, he's a strength and conditioning coach and works mostly with soccer.
Oh, soccer. Fantastic. Well, congratulations and welcome to you. Any comments from other members of the court?
I would suggest that with the photographer here, they may want to take their mask off at the podium just to get a nice picture.
Sure.
Thank you.
Here you go.
Get a picture.
Alex is on the move now. Alex is on the move.
Justice Walker?
Well, while you're getting some photos, I'll just echo the Chief's sentiments welcoming you to the West Virginia Bar. We love admitting people in person. There are very few, if any, Supreme Courts in the country that give the opportunity for every single person admitted to our bar to come to this courtroom with us here. no closed circuit television, no overflow rooms. We do it here. We do as many sessions as we need to. Of course, we've adapted to COVID, and understandably, people have appreciated the opportunity not to, for health reasons and all other reasons, but we love having people here in person, and it's my favorite time on the bench to welcome new lawyers to West Virginia. I hope that you find your practice here, at least part-time and full-time for the foreseeable future, is as enjoyable as mine was.
Thank you.
Thank you, Justice Walker. Justice Armstead?
Well, good morning, and we're very pleased to echo the sentiments of my colleagues. We're very pleased to have you here. You know, you mentioned Garrett County. I think any of us who've ever gone to the Eastern Panhandle in the winter have gone through that area.
We're about to drive this morning, to be honest.
So we're very familiar with that area and welcome you to be a part of the West Virginia Bar, and I hope you have a very successful practice here.
Thank you.
Mrs. Vestal, we certainly appreciate the opportunity to welcome you as well, and hope you enjoy your time with the legislature. Three of us have been a part of that process in the past, and so we know exactly what you're going to be facing for the next 60 days. It's a pressure cooker, but very exciting and very enjoyable, I'm sure. So wish you the best there as well, and hope to see you all both back here practicing in front of our court in the future.
Thank you.
Justice Hutchison?
I welcome you. Thanks for coming. A couple of individual things. In a former life, when I used to coach basketball at Davidson Elkins, I spent a lot of time at Garrett County Community College recruiting, because there were lots of really good teams and players that came through there. But that was the good part of it. Driving up there in the middle of the winter was, as Justice Armstead alluded to, is not always a fun thing to do. But it's great. It's a great area. I mean, you know, it's a lot of fun. Where did your husband play college soccer?
He played at Belmont.
Okay, my daughter played college soccer at Davidson Elkins up in the center part of the state. So we're big soccer fans in my house, and believe me, I know how hard those guys have to work to, you know, get in shape and stay in shape and be able to do that. So congrats on the job at Marshall. Great university. I think, you know, the support down there for the programs is well, it can't be matched by any place in my mind. So I welcome you here. I was not a member of the legislature, but I had to deal with legislative counsel in my former life as a circuit judge whenever we were down here trying to get legislation passed. So I know how hard that's going to be for you. You're going to get lots of friends, people that are going to want to talk to you. But welcome to both of you.
Thank you.
Justice Wooten?
I would echo the comments of my colleagues. Congratulations to both of you on your accomplishment. Welcome to the West Virginia Bar, and good luck to you.
Thank you.
Fantastic. Again, congratulations. Carol, thank you again for all you do. Appreciate your leadership, and we wish you all the very best.
Thank you.
Have at it.
Have a great
All right, we will begin oral arguments this morning with the Rule 20 docket, State of West Virginia versus Timothy Michael Connor II, docket number 20-0234, and this case is being presented under a certified question from the Circuit Court of Monongalia County. Counsel, I want to let you know that you'll notice we've installed plexiglass on the bench so the justices are able to remove their masks so that you can better understand at least their diction when they're asking you a question. They are also properly distanced from the rest of us in the courtroom. We've also added plexiglass to the counsel table, so if you would like to remove your mask and put the microphone cover over the microphone when you approach the podium, you may do so. We have put a clock on the table to the left of the podium so that you can self-monitor your time. Under Rule 20, you each have 20 minutes to present your oral argument. The petitioner is entitled to open and close the argument, but just make sure that you save yourself some of your 20 minutes to be able to do that. And with that, counsel, you may proceed.
Good morning, Jared Moore on behalf of the petitioner Timothy Michael Connor. Chief Justice Jenkins and fellow justices, a criminal statute must be sufficiently clear and definite to provide a person of ordinary intelligence fair notice that certain conduct is prohibited by law. The average person should be able to read a criminal statute and know what it means, what it prohibits, and what it requires. A criminal statute must also provide adequate standards for adjudication. Criminal laws cannot be enforced in an arbitrary manner. The failure to render aid statute, West Virginia Code 60A-4-416B, does not satisfy either one of these requirements. As a result, it is unconstitutional under the void for vagueness doctrine.
Counsel, have you been able to identify anywhere in the country where there's a criminal code that requires a certain action, like in this provision, and absent such action, you're subject to criminal penalties?
Justice Jenkins, the answer is no. I would point out that the state of Nevada has a criminal provision that provides for an additional penalty for someone who knowingly fails to seek medical assistance if that individual is first convicted of either delivery or delivery of a controlled substance resulting in death. But that specific code section is clear that it is not a separate offense, but only an additional penalty. So, in short, the answer to your question is no. West Virginia, to our knowledge, is the only state in the United States that has a separate criminal offense for this type of conduct. The relevant part of this statute reads, any person who, while engaged in the illegal use of a controlled substance with another, who knowingly fails to seek medical assistance for such other person when that other person suffers an overdose or a significant adverse physical reaction. Two questions emerge from the language of the statute. First, who does it apply to? And second, what specifically does it require? In looking at the first part of this statute, the category of person within the scope, the Circuit Court correctly recognized that this statute is unclear as to whom it applies. Does it apply to someone who is personally using a controlled substance with an overdoser? Or does it apply to someone who is not personally using a controlled substance, but who is physically present with an overdoser? We do not know the answer to that question based upon how this statute is written. Justices, this is a unique case in which the record evidence shows different and conflicting interpretations by the state of West Virginia with regard to the category of person within the scope of this act. In the trial court, the prosecuting attorney of Monongalia County, who is certainly no stranger to prosecuting drug offenses, construed this statute to apply to a person who was not using a controlled substance, but who was simply present with an overdoser when that occurred. Specifically, at the February 21st hearing last year, the prosecutor specifically said, "I think it would encompass someone with someone who is engaging in drug use." As it relates to the first part of this statute, the record evidence shows that the petitioner, Timothy Michael Connor, was charged because he was with Shane Sebulek when he overdosed. There is absolutely no evidence, none whatsoever, that Mr. Connor was personally using a controlled substance or that he was under the influence of a controlled substance together with or alongside Mr. Sebulek when he overdosed. There is no evidence that Mr. Connor supplied or paid for the drugs. There is no evidence that Mr. Connor aided, abetted, or assisted Mr. Sebulek in his use of the drugs. Mr. Connor was physically present, and as it relates to the first part of this statute, that's the reason why he was charged. On this appeal, the state has completely rejected the prosecutor's interpretation. A criminal statute is ambiguous if it is subject to two or more constructions or if reasonable minds disagree as to its meaning. For the state to now argue that this statute is so clear, so unambiguous as to overcome this constitutional challenge, it would necessarily have to state that the prosecutor's interpretation was unreasonable. Now, as a practical matter, the prosecutor's interpretation was shared by the magistrate who issued the arrest warrant, a different magistrate who found probable cause at the preliminary hearing, as well as the grand jury, 16 people of ordinary intelligence. Mr. Connor's physical presence was the only basis in which probable cause could have been found as it relates to the first part of this statute. Additionally, for the first time on appeal, the state has advanced a third category of person arguably within the scope of this statute, someone who possesses, procures, or sells a controlled substance. That third interpretation was not recognized in the circuit court by either the defense, the prosecutor, or the circuit judge. And while the petitioner disagrees with that interpretation, it is not a far-fetched or an unreasonable interpretation based upon how this statute is written. That third interpretation only serves to highlight the vague nature of this statute. In the trial court, this statute was construed one way by reasonable minds. But now on appeal, it is being construed in a different way, again, by reasonable minds. The fact that the state of West Virginia cannot agree on what this statute means is evidence that it is unconstitutionally vague. The second unclear part of this statute requires a potential offender to seek medical assistance for someone who is overdosed. What does seek medical assistance mean? What is required in order to seek medical assistance? Does seek medical assistance require direct action, or is it sufficient for someone to take indirect action? We do not know the answer to those basic fundamental questions because the legislature did not define this particular phrase, and there is nothing in the legislative history to show legislative intent. Without a definition and without any guidance from the legislature, this statute fails to provide adequate standards for adjudication and can be enforced in an arbitrary manner.
Well, council hasn't 1647-3, which is the, I think it's called the Overdose Prevention Act or something like that, defines emergency medical assistance. And so hasn't the legislature actually in that statute given us an idea of what it means to seek medical assistance?
Justice Hutchinson, great point. That statute relates to emergency medical assistance, and it defines emergency medical assistance as medical services provided to a person who may be experiencing an overdose by a healthcare professional licensed, registered, or certified under either Chapter 30 or Chapter 16. It does not, however, actually define seek medical assistance. The definition is limited to emergency medical assistance, which under that definition would not include a law enforcement officer. So that definition would be insufficient to provide guidance to this particular statute. I would also note that that particular immunity statute is limited to certain enumerated offenses. There are a total of 10 enumerated offenses contained in that statute, only one of which relates to a drug offense, which is 60A-4-401C, which is the simple possession criminal offense.
But that statute also gives, in this case, immunity to a parolee who seeks medical assistance for somebody that is overdosing, and if he does it, the fact that he was around the drugs or around somebody that was using drugs can't be used against him in a parole violation hearing, right?
Justice, I'm not familiar with that particular provision. It's my understanding that only the enumerated offenses contained in Section 4 would be subject to immunity under that particular statute. I'm not familiar if whether a parolee, that certainly could be the case.
I think it is.
As it relates to the second part of this statute, the category of person within its scope, the record evidence demonstrates that Mr. Connor was charged and prosecuted because he did not drive Shane Sebulek to the hospital directly, or because he did not personally call 911. The record evidence shows that when Mr. Sebulek overdosed, Mr. Connor called Joseph Choma, a friend who he knew to be a nurse. Mr. Connor drove Mr. Sebulek over to Mr. Choma's house. 911 was contacted, and Mr. Choma provided the 911 dispatcher with various information related to Mr. Sebulek's location and his condition. As a result of Mr. Connor's actions, 911 was contacted, and police, fire, and EMS personnel arrived at the place where Mr. Sebulek was last seen, although they were ultimately unable to locate him. Because we do not know specifically what seek medical assistance means, some individuals may subjectively believe that Mr. Connor's actions did constitute seek medical assistance under those circumstances. Others may not.
Isn't that a jury question?
Great point. In United States versus Williams, the court recognized that a statute is vague not because it may be difficult to determine whether the fact has been proven, but rather the uncertainty in what that fact is. A jury decides if a particular standard has been proven. A jury does not decide what that standard is. And because we do not specifically know what seek medical assistance actually means, the jury would have to use their subjective determination to decide whether or not the conduct met the standard of seeking medical assistance.
Counsel, you have about 5 minutes left. If you want to reserve any time for rebuttal, you may want to be conscious of that.
I will, Justice. Thank you. In closing, briefly, the Circuit Court correctly found that this statute is unconstitutionally vague on two separate grounds. We ask this court to answer the first certified question in the affirmative and the second certified question in the negative, because this statute is unclear and it is ambiguous. Thank you.
Good morning, counsel.
Good morning.
You may proceed.
May it please the court, my name is Gordon Mowen on behalf of the state of West Virginia. West Virginia Code section 60A 416B is not unconstitutionally vague. It plainly identifies the groups of people who fall within its scope. The statute penalizes those who are engaged in the illegal use of a controlled substance with another person, who fail to seek medical assistance on behalf of that person when that person overdoses. The statute only includes people who are engaged in the use of drugs. That's someone who's consuming drugs alongside the overdoser, someone who supplies or obtains drugs for the overdoser. But contrary to petitioner's argument, it does not include people who are simply close by, who have nothing to do with the drugs. This close proximity concern was the concern underpinning the circuit court's belief that the statute was unconstitutional. But we can put that concern to rest pretty easily because there's no language in the statute from which you could infer that simply being close by is sufficient to fall within its scope.
So in this case, the judge should have dismissed the indictment?
No, Your Honor.
Because there's no evidence, at least from the information provided to this court, there's no evidence that the defendant did anything other than sit in the truck while the deceased smoked the drugs. There's no evidence that he was under the influence. There's no evidence that he had anything to do with supplying the drugs. And there's no evidence that he encouraged or assisted the deceased in using the drugs. So in this case, the indictment should have been dismissed because it says anybody who, while engaged in the illegal use of drugs with another. So if this guy didn't do anything, he should have been dismissed, right?
Well, Your Honor, no, and for two reasons. The first is about this case. This is a certified question where the issue is whether the statute is constitutional as written. It's a facial challenge versus an as-applied challenge where the court connects the facts to a statute at issue. But this is actually a facial challenge which asks a far more fundamental question. A facial challenge considers whether there's a defect in the statute that renders the statute unconstitutional in every aspect of the law. In other words, and as the Ohio Supreme Court recently recognized, a facial challenge will prevail only where the statute is unconstitutional in all applications. So if we're looking at the facts of the case, that turns into an as-applied challenge, whether the individual falls within the scope of that statute. That's not what we have here. That would be, for instance, like a direct appeal, right, where the record is fully developed and we've got a verdict and there was a jury fact-finding. My answer, however, to your specific question is this. The statute requires a person to be engaged in the use of a controlled substance with another, and the definition of use is broad when it's used conventionally, which is just how the legislature used it. And here I am, I've just said use 3 times in the last sentence, all signifying different things. Petitioner in this case was instrumental in procuring the drugs. He went with the victim to the apartment complex where the heroin was obtained, and then he hung out with the victim just outside their vehicle in the parking lot while the victim consumed the drugs. And it's the state's position that this falls within the scope of the statute. Again, at the very least, this is a fact-bound question that is best left for the circuit court or a jury if it gets to that point. But because resolution of an as-applied challenge is fact-bound, the as-applied challenge is not why we're here today. This is a facial challenge to the constitutionality of the statute. But
Counsel, on that issue, can you cite any case law or any other statutory provision that would bring procuring the drug into the definition of use?
yes, yes, absolutely. So the case law is this court's own canons of statutory interpretation, which says when the legislature does not define a word, a non-technical word, this court affords that word its ordinary common meaning. And everyone in this room, I believe, agrees that the legislature did not define the word use in this statute. It's undefined. And so, according to this court's precedent, we look to the common, ordinary meaning of that word. Use is a very interesting word. It's almost paradoxical. I can give an example. For instance, I use my car to go places, but since COVID, I haven't had to use it. Use both connotes that I have a car that I use, but I'm also saying I don't use it. And so the definition is contextual, and I've paraphrased an example given by SCOTUS in the Smith case. And so, Your Honor, the answer to the question is use is broad when otherwise undefined by the legislature, and in this case, it appears as a noun. So again, following the court's canons of statutory interpretation, use means the privilege or benefit of using something, the act or practice of employing something, or the fact or state of being used. So taken together, this means one who sells drugs for monetary gain or possesses and gives drugs to another user is using the drugs just like someone who's consuming it. I do have a case, Your Honor, and that's United States, Smith versus United States, which is a 1996 opinion from the United States Supreme Court. And in that case, there was a federal statute that said, if you use a firearm during a drug trafficking offense, you get a higher penalty. It was a sentence enhancement statute. And the individual, Mr. Smith, in that case, traded a gun for drugs. And he claimed throughout his proceedings and then on appeal, and it went all the way up in front of the United States Supreme Court, he said, hey, I wasn't using the gun the way Congress meant it. They meant if I use a gun like to brandish or to coerce the sale, I didn't use the gun in a drug trafficking offense. I used it to trade it. I bartered with it in exchange for the drugs. So he raised a very similar constitutional challenge as that presented in this case. And the United States Supreme Court said no. When Congress chose not to define the word use, they didn't cabinet. And so you are using a gun for a drug trafficking offense if you're brandishing it, or if you're threatening the person to get the drugs or to force a sale, but you're also using it if you're trading it, or you're bartering it, or you have any type of gain from the use of the gun, you are using it. And that, Your Honor, is exactly the definition that we propose be interpreted by this court for purposes of this statute. So I'm not just using a drug by consuming it. I mean, certainly I am. I don't think anyone would disagree with that. I'm using a drug if I smoke it or inject it or however other ways people consume an illegal drug. But I'm also using a drug if I'm selling it to someone else or if I'm giving it for a benefit, because that falls within the quintessential definition of use for purposes of this statute. Your Honors, the next point I would make is the issue with the engaged in language. To be engaged in the illegal use of a controlled substance obviously is relevant to the statute. It narrows the scope, so those who are engaged in the illegal use of a controlled substance fall within it. As I've outlined, that applies to someone who's consuming it directly, selling it, procuring it, giving it to someone else who's going to overdose. I'm now happy to turn to the second certified question, which asks whether the term seek medical assistance is constitutionally vague. The phrase seek medical assistance does provide an adequate standard for adjudication, and therefore it is not ambiguous. The statute says you've got to seek medical assistance for the overdoser if you know the overdoser is overdosing. The circuit court believed below, and petitioner argues here, that this standard is void for vagueness because it provides no standard for adjudication. That's wrong. The phrase seek medical assistance is not ambiguous. Read in context, this is an element of the offense. And the element of this contains both a mens rea and actus reus requirement. The mens rea requirement is very clear. It says knowingly. You must knowingly be aware that the user is overdosing. This court has defined knowingly in a number of cases. Syllabus point 1 of State versus Wyatt is a great example. Knowingly means to be aware of. The actus reus is also clear, and that's the verbiage that really seems to be underpinning petitioner's challenge here, which is to seek medical assistance. But again, this court has very well-established canons of statutory instruction. And so the first question is the language ambiguous? And the answer is no. And if the language in a statute is unambiguous, this court will not interpret it. Instead, it will apply it as it is written. Now, petitioner is correct that the phrase seek medical assistance was not defined by the legislature. But again, as this court has recognized, time and time again, when the legislature uses language that is not specifically defined, it applies the common, ordinary meaning of those terms. These terms are not difficult to define. Seek, it's a transitive verb, as it's used in this sentence. Seek means to go in search of or look for. Assistance, seek medical assistance. Assistance is a noun and means the act of helping or assisting someone. And then medical, of course, modifies the word assistance, and it's an adjective, and it means requiring medical treatment. We're just breaking these terms down to its common, ordinary meaning, which is what this court's well-established precedent says to do when the legislature doesn't provide an express definition for non-technical terms. So taken together, to seek medical assistance means to go in search of or look for medical treatment. It means contacting someone who can get this person who's overdosing medical treatment. It strains belief, it strains common sense to suggest that the notion of seeking medical assistance is so ambiguous that no reasonable person can understand what that means. I know and I recognize that a large component of my opposing counsel's argument was this notion that the circuit court believed it was one interpretation and another party believed it was something else, and 3 or 4 or 5 other people had something else to say about it. But the reality is this court reviews all of those questions de novo. It does not matter what the circuit court believed this statute meant below. There is no deference given to a circuit court's conclusion of law, much less when the constitutionality of a statute is challenged. I would also like to point out that the prosecutor's position with respect to the scope of this statute is consistent with the position that the state is advancing today. I mean, the state, viewed in isolation, the proximity question was a question that was that took up a lot of time during the hearing below. But the state was responding to a series of hypotheticals posed by the circuit court to engage in that discussion. Of course, the state also took the position that petitioner was instrumental in the victim's procurement of the drugs and was there and hanging out with him when the drugs were consumed, and that would fall within the scope of the statute. And that is not inconsistent with the position the state is taking today. But of course, either way, construction of this statute, the constitutionality of this statute, is reviewed here de novo. Your Honors, the statute is constitutional. It should not be stricken down, particularly given that when evaluating the constitutionality of the statute, this court construes the statute in favor of the legislative enactment. So for those reasons, we believe that the first certified question should be answered that the statute, the phrase is constitutional, and then the second question should be answered that the term seek medical assistance is not ambiguous.
Did I understand you to say that that the state's position is that if someone is merely present while someone else is using an illegal drug, that constitutes being engaged in the use of the drug?
No, Your Honor. Mere proximity is not sufficient under this statute. And in fact, the pleadings, for instance, use an example of a person at a spectator, I think at a concert or a sport. So if I'm at a concert and I'm at Woodstock and there are people around me doing drugs and the person next to me who I don't know and I've never met consumes heroin and begins suffering from an overdose, I am not guilty under this statute because I was not engaged in the use of the controlled substance with this person.
Suppose though, that this other person picks you up in his vehicle, drives to a location, exits the vehicle and procures the illegal substance, comes back to the vehicle, and then this other person consumes the drugs, and you do nothing but sit there all the time. Are you engaged in the use?
Your Honor, that it's a fine edge, certainly. But if I have nothing to do with the drugs whatsoever, then I am not subject to this statute because the language says I must be engaged in the illegal use of a controlled substance with another. However, if there are facts tending to indicate that I assisted in procuring the drugs for this individual or otherwise gave an incentive for this person to consume the drugs, then I am engaged in the illegal use of that controlled substance with this person because I'm helping to facilitate that overdose. That's the distinction that the state would draw in this statute. It's also consistent with the evidence in this case. I recognize, Your Honor, that the fact pattern you provided is strikingly similar to the facts underpinning this certified question. But it's really a question of degree. How involved was I in the overdoser's consumption of the drug? And Your Honor, that turns very carefully on fine-tuned facts. But if I am instrumental in the procurement of those drugs, or if I'm with the person and providing them with some incentive to consume the drugs, then I'm engaged in the illegal use of that drug with that person for purposes of the statute, given the broad definition of use.
Then you're suggesting that had this case gone to trial, the state would have been obligated to produce evidence that the defendant was in some way engaged in the procurement or encouraged the use of the drug?
Yes, Your Honor, that's correct. Thank you.
Thank you, counsel. If the petitioner would like any time for rebuttal.
This matter is before the court on a certified question. There has been no jury trial. Having said that, because this particular statute does not involve First Amendment freedoms, Syllabus Point 3 of State v. Flynn requires this court to test the statute for certainty by construing it in light of the conduct to which it is applied, i.e. the conduct of Mr. Connor. Justices, it is of the utmost importance for an attorney to be able to advise a criminal defendant whether the alleged conduct, if proven to a jury, constitutes a violation of the statute under which that defendant stands charged. That cannot be done with this particular statute. Turning to the second part of the statute, the state suggests that this court can give the phrase "seek medical assistance" its common, ordinary, and accepted meaning. The problem with that is there is no common, ordinary, or accepted meaning of that particular phrase. As pointed out earlier, we have been unable to find any other statute from another state that imposes direct criminal liability for failing to seek medical assistance. Several states, like West Virginia, have adopted particular statutes that provide immunity from prosecution for certain offenses when an individual seeks medical assistance for someone who is overdosed. The important point, however, is that the states that have defined that phrase have done so in a different manner. Those definitions range from number one, reporting or contacting police, 911, a poison control facility or a medical facility, 2, transporting someone to a medical facility, 3, accessing medical assistance, 4, assisting in contacting, reporting, or accessing medical assistance, 5, providing care, or 6, some combination of the above. The fact that other states have defined the phrase, and more importantly, the fact that they have done so in a different manner, shows that this statute is vague. Secondarily, the state proposes that this court adopt a specific definition of the phrase seek medical assistance. Respectfully, only the legislature can do that. This court cannot, under the guise of interpretation, modify, revise, amend, or rewrite a statute. That would have to be done in order to adopt the state's proposed definition. If a statute is going to deprive an individual of their freedom based upon the failure to take a certain act, that statute should be crystal clear in describing the act that is required to be taken. This statute does not do that. We ask this court to find the statute unconstitutional on the 2 grounds raised and declare it void for vagueness.
Counsel, I understood counsel for the state to say that the phrase engaged in the illegal use of a controlled substance with another, as applied in this case, would require the state to produce evidence that the defendant was somehow involved in the procuring of the illegal substance or somehow encouraged or assisted in the use of the substance. They would have to produce that evidence at trial. Given that standard by the state, why is the statute unconstitutional?
Because that is a reasonable interpretation based upon how the statute is written. It's our position that it is also a reasonable interpretation that someone who is physically present would fall under this statute, and a statute is unconstitutionally vague if reasonable minds disagree as to its meaning. Both the circuit court and the prosecuting attorney of Monongalia County recognized that the physical presence interpretation was a reasonable one. And since reasonable minds have disagreed, particularly by the state of West Virginia, that's what makes this statute unconstitutional. Thank you.
Thank you, counsel. This case will be submitted.
The next case for oral argument is also being presented under Rule 20. And counsel, in this case, I want to let you know that the court has installed plexiglass panels on the bench, so they are able to remove their masks, and they are also distanced far enough away from us in the courtroom. On the counsel table, we've installed plexiglass so that when you approach the microphone, if you choose to remove your masks and take off and put the microphone cover on, you may do so. Each of you are entitled to 20 minutes for your oral argument. That includes the rebuttal time for the petitioner. So you can self-monitor your time. We've placed a clock to the left of the podium there on the table, so you can reserve a few minutes for your rebuttal time. With that, I will call the case, State of West Virginia versus Kevin Travis Costello, docket number 190326, an appeal from the Circuit Court of Jefferson County.
May it please the court, my name is Matthew Broman with Public Defender Services, and I'm here today on behalf of the petitioner, Kevin Costello. Your Honors, I welcome question on any of the assignments of error in this case, but I suspect the court is most interested in the mistrial and the directed verdict issues, so I'm going to focus my time, most of my time there. Starting with the mistrial, The issue here is whether there's manifest necessity for a mistrial. And that is based on surprise and prejudice. Here, there were three main reasons that the defendant was unfairly surprised by this testimony coming in. First is the simple fact that that the testimony in question was not disclosed pre-trial. The defense had requested it in discovery. This specific question was asked to the prosecutor, and the prosecutor said that the probation officer could not remember anything of his discussion with my client. And the other reason, the second reason that this disclosure was unfair is because this was not just ordinary evidence. This was an alleged confession made to a law enforcement officer, a complete confession, not merely an admission. Under those circumstances, the state bears the burden of proving proving by preponderance of the evidence that the confession is in fact voluntary. And I understand this court has recently said that that does not change the fact that the defense must first request a hearing, but this makes it all the more important that disclosures of this nature come forward. The whole reason in Brady that we have to worry about police officers withholding exculpatory evidence is that they may feel an incentive to withhold or to view the evidence in a way disfavorable to the defendant. But with inculpatory evidence, it's all the more reasonable to assume that the law enforcement officers involved are going to be fully candid with the prosecution. So for those reasons, it was perfectly reasonable for the petitioner to rely upon the lack of disclosure in this case and to plan a defense accordingly. Finally, the third reason that this was an unfair surprise, and this was specifically renewed in the motion for a mistrial, was that the testimony seems to violate West Virginia Statute 57-2-3. This prohibits the use of statements made by a defendant in a criminal case that were originally made in a legal examination in an ancillary matter. This statute is very old. It goes back to Virginia, but the policy that it serves is still very important today, and that is this weighing of the defendant's right to not incriminate themselves in a criminal matter and the state's right to investigate thoroughly matters not relevant to that.
Counsel, help me. Process was petitioner's counsel never objected to the testimony, never objected during the direct, did not object during redirect, and put forth the mistrial motion after the testimony was completed. And we obviously have case law under State v. Johnson that says in determining whether or not to grant a mistrial, consideration has to be first given to whether or not the counsel objected during the direct examination. Why? Hasn't he missed his opportunity here? And the appropriate decision was not to grant a mistrial for failure to object either during direct or cross?
I appreciate, Your Honor, that those are circumstances that should be taken into account. Not all mistrials and not all objections are created equally, and we need to look at the specifics in the case at hand. Here, the defendant did wait until after the conclusion of the witness's testimony. However, I don't think that matters here. First, because of the degree of surprise and prejudice resulting from the testimony, nothing that could have been done immediately afterwards would have fixed anything, could have changed anything. And the other reason is that it appears that the defense counsel was following the court's order.
Let me ask you, it couldn't have been done. Couldn't the court have taken a recess if requested and allowed this to be sorted out and given the defendant an opportunity?
Seeing as it completely undermined the entire defense plan, I don't think a recess would have been important. But back to your original question, Your Honor, the trial court had ordered the defense lawyer to wait until witnesses were done testifying before raising issues, just a few witnesses before this testimony. So it appears that the defense lawyer may have been just following the court's order to wait. So that I think goes to the timeliness of this as well. But ultimately, with any mistrial motion, it all comes down to the prejudice and the problems that creates. And I think in light of how severe the prejudice was in this case, the lack of timeliness doesn't really change anything. I don't think a recess would have changed anything. And there's two bases for the prejudice in this case that are both extreme. First is, of course, the fact that this completely demolishes defense, just as what happened in State v. Smith. where this court found that, defendants don't have a right to lie or fabricate a defense, but they do have the right to prepare for their defense, knowing in general what the state has in store for them. And this completely undercut everything that the defense had planned. And the other reason that this was prejudicial is because of that policy I mentioned under 5723. The result of this was that it compelled my client to testify, and it was proffered that he may not have if this evidence had not come in. And that's really the policy underlying 5723, is that if the state can use statements you make in ancillary matters under legal examination against you in later criminal cases, then the defense basically has no choice but to put the defendant on the stand, because they need to be able to say something about what they said earlier. It's essentially their hearsay statement being used against them.
Isn't the general rule, though, that in ancillary proceedings, statements of that type are not necessarily admissible unless they're used to impeach a statement by the defendant?
I think that's absolutely right, Your Honor, and I think that's why West Virginia struck this balance with 5723 as opposed to applying blanket immunity. If people had immunity from their statements in prior ancillary proceedings, then you couldn't even cross-examine them. The defendant would basically have license to get up and lie. Instead of striking that balance, what the legislature has done is said that it doesn't come in the state's case in chief, but that doesn't mean it can't be used for impeachment. Here, obviously by virtue of the order of operations, the prosecution went first, and the defense and the defendant had not yet testified. And looking at the theory of the defense based on opening statement, it appears that they were intentionally leaving that open-ended to possibly rely exclusively upon reasonable doubt and to not bring in the defendant's statements to be subject to impeachment. Because the state brought...
The real question was, did he take the drugs after the wreck to get rid of the evidence, or did he take the drugs before the wreck?
That is the question, Your Honor, and there's two ways the defense could go about doing that. One would be putting the defendant on the stand to testify to that. The other would be to just raise a reasonable doubt about whether he hadn't done that. And by introducing this alleged confession in the state's case in chief, where it had no business doing so, it forced my client's hand. At that point, he had to testify, and he had to explain these comments that had been made. Moving on to the directed verdict issue, Your Honors, the substantive offense for a recidivist is found in 61-11-18, and it makes it very clear that an element of that offense is that the prior convictions were for offenses that would subject you to a penitentiary sentence. That's clearly on the face of it, that's written into the statute. I don't think there's any reasonable question that you get a higher sentence if those convictions are felonies as opposed to misdemeanors. The only issue is who needs to find that fact. And just like every other element in every other crime that has a definite legal definition, the answer is still the jury. The court gets to define the element. The court gets to say a sentence subjecting someone to a penitentiary term is a felony, which means it's greater than a year confinement. But ultimately, the jury has to connect that to the facts, not the judge. In fact, this exact same situation arose in a United States Supreme Court case, U.S. v. Gowden, in 1995. There, the statute in question was a federal perjury statute that required that the false testimony be material. And the circuit courts had previously held that, many circuit courts had previously held that materiality was a question of law, and that as a question of law, it was to be decided by the judge. The state would only have to prove the predicate facts, making it material, and then the judge would connect those dots. And the Supreme Court easily said that that's not how this works. We don't submit interrogatories to juries. We don't ask them to find each element individually. We ask them for a general verdict. Is the defendant guilty? Or in this case, is the person the same person previously convicted? And in that situation, every verdict is always a mixed question because the jury applies the law given to them by the judge. This is unusual in that it's a pure directed verdict situation. The judge told the jury that this was an element of the offense, that it had to be a penitentiary term in order for them to find identity. And the judge then went a step further and relieved them of that and said, and explicitly told them, as a matter of law, these underlying convictions were felonies. So if you find that he was convicted of them, then you should convict. And that is a pure directed verdict situation, and it has long been the law in this country that is not only an error, but it's structural error. It goes to the very heart and structure of what a criminal trial is for. The purpose of a criminal trial is for a jury to determine whether you're guilty, not the judge.
Well, in this case, what was presented to establish that the petitioner had a Maryland conviction, the state produced docket sheets, documents related to the arrest, the courtroom worksheets, the commitment order, the probation supervision order. A great deal of documents were presented to the jury to establish, and the jury so established that the petitioner had been convicted of this offense in Maryland. But once the jury determines that he had that conviction, isn't it an issue of law whether or not it meets the recidivist statute, and not still a subsequent question for the jury to say, well, we do believe he was convicted, but now we have to start looking at our recidivist statute to see whether it meets the mark. The mark is pretty well defined in the court as a matter of law. While we don't have a syllabus point in West Virginia on this, that's what we're really looking at here, are we not?
It is, Your Honor, and it's a question that thankfully is easily answered for us by the Supreme Court in U.S. v. Gaudin. It is absolutely a question of law, the definition of a felony. This jury was not free to say to themselves, we don't think they meant the modern definition. We think that the legislature really meant common law felony. They're not empowered to do that. They have to apply the law given to them by the judge, and the judge defines what a felony is. But the tying it together, the applying of the law to the facts, is fundamentally up to the jury, period. That's the import of U.S. v. Gaudin. And you touched on something too, Your Honor. You mentioned the documents used in particular to show the Maryland conviction, and I think that is worth a little more attention. For this, we turn to the procedural aspect of a habitual offender statute, though, 6111-19. And it doesn't provide, and what you see in the statute is that it provides that the state prove identity in a very specific manner. The state is only allowed to prove identity by virtue of bringing forth the records of conviction and sentence, or sentences as the situation may be. That is the means by which the state has to show identity. It is not in the abstract were these crimes committed by the defendant. The issue is, is the defendant the same person named in these records of conviction and sentence? And that we don't have for the Maryland conviction in this case, Your Honors. The closest we come to anything like that I found was the commitment order. There was a commitment order entered in the Maryland conviction. However, if you look at this in the appendix record, you'll see that it looks nothing like a commitment record in West Virginia. Oftentimes, our commitment orders look like the sentencing order redux. They still go through that the jury found them guilty, the jury did this, the jury did that. I don't think that the commitment order in Maryland does that same thing, and I don't think it stands as a substitute for a sentencing order. And so by virtue, not as a matter of proof per se, but as a matter of the procedure by which the state is allowed to show identity, I don't think that the Maryland documents really get there. You can certainly have ancillary things to tie up loose ends. I've seen cases where a defendant had a twin brother, for example, and they introduced fingerprint evidence to try and make it clear that this was the same person. You can use that to tie up loose ends, but ultimately the state needs to show identity as being the same person mentioned in the records of sentence and conviction, and that wasn't present here.
Counsel, was your client denying that they actually were convicted of this crime?
I don't immediately recall if he denied it or if he stood silent. The statute allows him to do either. And standing silent has the effect of holding the state to its burden of proof.
It seems to me like you're, going back to Chief Justice Jenkins' questions, it seems like you're almost asking the court to retry the underlying crimes and determine what the nature of them are. And if it's truly a legal question for the court to determine whether a crime is a felony or a misdemeanor, wouldn't that pretty much rely basically on the records that were introduced here?
Yes, that is absolutely right, Your Honor. However, it's still, the legal and factual still needs to be united by the jury, not the judge. The judge instructs the jury on what the element means, and then the jury has to find if that's been satisfied. And that's what you don't have in a directed verdict situation like this, where the judge says, don't worry yourself about that element, I found it as a matter of law. This is completely different from every other recidivist trial that I've ever been involved in. Usually it happens exactly that way, just like any other crime. The judge instructs, a felony means X. If you find X, then you can find identity. That's how it is usually, and you'll have, and you could even have, even if you didn't want to rely purely on the judge's definition, I've seen situation where witnesses for the state have said what a felony is. That's another way to go about it if you want to supplement that. But ultimately, the jury has to make the determination. The import of U.S. v. Gaudin is that there is no difference between what happened in this case and a judge in a burglary prosecution saying, as a matter of law, this was a dwelling house. Therefore, if you find the predicate facts of the breaking and entering, it is a burglary.
Counsel, you have about 3 minutes left. If you'd like to reserve any time.
Thank you, Your Honor. I'll reserve that.
Thank you.
May it please the court, Your Honors. My name is Andrea Neese-Proper, Assistant Attorney General on behalf of the state of West Virginia. As petitioners failed to prove reversible error, the petitioner's recidivist sentence of life with mercy should be affirmed. I'd like to begin with the recidivist, as the court just dealt with this issue. I find it interesting that Justice Jenkins suggested that we do not have a syllabus point on this issue, which is quite true. The state, however, posits that a proper syllabus point in this case would be something to the effect of the character of an offense under the recidivist statute, being whether or not said offense is a felony or a misdemeanor, is a question of law, not a question of fact for the jury. This would put West Virginia in line with several other jurisdictions, most of which are cited in the respondent's brief, including California, Arkansas, Illinois, Indiana, Oklahoma, Virginia, Washington, Iowa, Colorado, New York, Louisiana, and the 1st and 11th Circuits. Specifically, in Indiana, Griffith versus State, the court stated that whether an offense is a felony is purely a question of legislative categorization. It is not a question of fact for the jury, but a matter of law predetermined by the legislature and applied by the judiciary. In People versus Haywood out of California, the same argument, is the exact same argument that is being made in this case was made there. The jury instructions were argued to be erroneous because they removed the determination of an essential element of the offense from the jury's consideration. That was petitioner's argument in Haywood. The court rejected this argument and found, quote, status of a particular crime as a felony or misdemeanor is a legal, not a factual question. In this case, as the state pointed out below, if the Maryland conviction was not considered a felony, then the petitioner could have easily just moved to dismiss. That would be a purely legal argument. And had it not been a felony, had it been a misdemeanor instead, then the court would have dismissed upon a motion to dismiss. The state also noted below that it's not the state's job or the court's job to basically teach the first year of law school and teach the jury what a felony is versus what a misdemeanor is, because these are simply questions of law. This court has found in State v. Syllabus Point 3 of State v. Hulbert, in reference to a third offense domestic assault statute where the 2 prior offenses had to be proven, that, quote, whether an out-of-state conviction satisfies the requirements of this state's enhancement statute is a question of law. Obviously, that's a separate statute, but it's very akin to this statute, since this is merely a question of law. and purely a legal determination. The court did not direct a verdict, and the circuit court properly found as much.
Counsel, petitioner obviously focuses a great deal on U.S. v. Goldina, I believe is his site. Do you have any response to his argument that holding would be dispositive of the issue in this case?
Well, that's quite different in that case, petitioner stated that it was a burglary case, and I believe that dwelling house was at issue. Whether or not the dwelling house is not simply a legal issue. This court has already decided, as I stated in State versus Holbert, that whether or not an enhancement statute is met by the prior crime is purely a legal determination. All this court needs to do is parlay that prior holding, which was from 2001, into the recidivist context. That would make this court fall in line with many other jurisdictions, as I noted or stated in the respondent's brief. As to the proof element in the recidivist, I believe Your Honor pointed out that there was a plethora of evidence presented to prove this Maryland conviction. The certified case summary, a charge summary, a sealed release document, a probation transfer form transferring petitioner's probation to the state of West Virginia, which I will note he was actually on probation for this exact Maryland conviction when this incident occurred, which is how we got to Mr. Lewis testifying. The testimony of petitioner's mother and girlfriend, all of these show that the Maryland conviction was a felony offense. The only elements, this court has noted that the two key elements are proof of the prior felony conviction and proof that the defendant is the person who was convicted of that felony. Petitioner seems to imply that a certified judgment order is somehow required but doesn't cite any law that states as much, because there is no law that states as much. This court has not said that you must produce a certified judgment order as the one single thing that will show that there was a prior felony in another action.
Is there any explanation as to why the judgment order from Maryland was not presented?
Your Honor, there's nothing in the record that states why there was no judgment order, but it's the state's position that it was simply unnecessary in this case. The state presented numerous documents, I believe 30 plus pages of documents from the Maryland conviction, and petitioner's family members to display that he was convicted. This was the same person who was appearing this. They showed his name, his address, his date of birth, his social security number were consistent throughout all these documents and consistent with the West Virginia conviction that had just occurred. So simply put, Your Honor, it was unnecessary to also have a conviction order. And I will note, importantly, these were certified documents from Maryland. These were not documents that were obtained in, some strange way. These were certified documents that were presented to the jury.
It just seems to me, going to the effort to introduce documents that were generated on the date of arrest, why not put in the judgment order to make it perfectly clear, rather than all these ancillary documents that you are suggesting would lead you to believe that such conviction of a felony was had?
The record, it doesn't reflect why that was done. This had become quite contentious by this point, and it's my feeling that the state wanted to ensure that all the proof that was necessary was put forward at this time. If the court doesn't have any further, the petitioner relies on a couple cases for this conviction order idea. One is State versus Meadows, a 1942 case. That case only notes that certified copies of judgments do meet the terms of the recidivist statute, but does not require that the certified judgment be entered. Really, we're just going to a sufficiency issue at this point. The jury found that there was sufficient evidence that this Maryland conviction was the same person, based on all of the evidence put forward. To turn to petitioner's first issue, Your Honors, the state's first response is that was brought up in petitioner's argument that this was waived. Petitioner notes that he chose not to object as a strategy. He chose not to cure this issue immediately. And as this court has stated in State v. McGilton, a litigant must raise a timely and proper objection during a trial, or he will waive his right to contest on appeal.
Counsel, did the circuit judge instruct defense counsel to withhold objections until the conclusion of a witness's testimony?
Your Honor, I'm glad you asked that question. What had happened prior to this was another witness was on the stand, and the petitioner's attorney, while that witness was on the stand, asked for a stipulation regarding the location of a grocery store in another town. That had nothing to do with the witness that was on the stand. The petitioner's counsel was actually referring to the victim in this case. He had testified that he had gone to another grocery store because he didn't have one in his town. Petitioner's counsel was attempting to make a point that there was, in fact, a grocery store in his town, but he wasn't making that point during the victim's testimony. He was actually making that point a couple of witnesses later, and the judge basically said, don't just jump up and ask for a stipulation, ask for judicial notice of something that has nothing to do with this witness. You're just confusing the jury. Don't do that. If you have something to say, wait till the witness is finished. If you have something to say that has nothing to do with the witness on the stand, wait till that witness has concluded, call a sidebar. That's wholly different than, he was not instructed, don't object. He was not instructed, don't call a sidebar. He was basically instructed, don't just jump up and yell something out that is not relevant to what we're talking about right now. And even with that noted, had he not objected at the moment the testimony was elicited, he could have objected and called a sidebar after the direct ended. A careful reading of the transcript in this case shows that the prosecution asked a question which elicited the statement, which everyone agrees in this case, the prosecution had no idea he was going to say this. The prosecution had interviewed him 4 times. He had never been told this. So the prosecution had no idea. The prosecution didn't even follow up on the statement, did not ask another question that had to do with this full confession that had just come out on the stand. And that would have been the perfect time to stand up and object, because, or even to call a sidebar so as not to direct further attention to this statement that had been made, because Mr. Lewis continued to testify not about this confession, but about other things that he was to testify to, and he could have brought up the sidebar. Instead, he chose as a strategy, and he admits this in the post-trial hearings, he chose as a strategy to cross-examine the witness, and then he allowed for a redirect. So another opportunity he would have had to have objected would have been after the cross-examination. He could have done it before the redirect. On the redirect, obviously the prosecution, since this had all been brought up again, did ask some questions on the issue. The other issue is petitioner claims a violation of Rule 16 and basically states that that the state violated the rules of discovery. This fails for a few reasons. First of all, Rule 16 requires that any relevant written or recorded statements be turned over. There were no relevant written or recorded statements. This was not written or recorded. It also notes that the state must disclose to the defendant the substance of any other relevant oral statement made by the defendant, whether before or after arrest, in response to interrogation, if the state intends to use that statement at trial. The state never intended to use this statement at trial because the state, frankly, did not know this existed. Petitioner has made a lot out of the voluntariness issue in this matter, but the court actually held an entire hearing pre-trial regarding 5723 and found that petitioner's statements to the probation officer were voluntary. So this was already done in reference to the 2 statements, the 2 signed statements. Also, it needs to be pointed out that petitioner doesn't deny he made the confession. He just didn't bother telling his counsel. And the circuit court was obviously concerned with this fact, that petitioner could sit on this confession and then claim error later when it, as he stated, backfired on him. Also, the petitioner didn't discuss it much today, but in his brief notes that this statement should be imputed to the prosecution and cites to Youngblood. However, petitioner ignores syllabus point 2 of Youngblood, which cites to Brady and states that for it to be imputed to the prosecution, it needs to be exculpatory or impeachment evidence. This wasn't exculpatory or impeachment evidence. As to petitioner's last assignment of error, which is the life recidivist, his sentence is obviously constitutional pursuant to this court's decision in Hoyle. Petitioner asked that this court revisit Hoyle, but this court actually did revisit Hoyle twice last term in State versus Plant, State versus Ingram. Both have strengthened Hoyle, and therefore petitioner's life sentence should be affirmed.
Thank you, counsel. Would the petitioner like any rebuttal? You have a little over 2 minutes.
Thank you, Your Honor. Excuse me. Start very briefly on the mistrial issue so I can get into the meat of this matter, which I think is the directed verdict. The issue with the mistrial is whether there was manifest necessity, and that exists in this case because there was surprise and prejudice. The specifics of Rule 16 I don't think control this. It's uncontested that the defense did not know about this testimony before it came in through the probation officer.
And for the same token, is there any evidence that the state had any evidence of such evidence?
You know, as much as I would like to disagree with some of the fact-finding below about the state's knowledge, the fact of the matter is whether or not the state was caught off guard doesn't change anything about the surprise the defense experienced. Doesn't change anything about the reasonableness of the defense relying upon the state's representations that the probation officer didn't remember anything.
How do you deal with the finding that the court made? I think, didn't the court make a finding in this case that even if it was error, it was harmless because of all the other evidence that would support the conviction?
A plurality of the Supreme Court has said that admitting an involuntary confession can be harmless error, but what all of the Supreme Court has always acknowledged is that it's very hard to get there. There's something peculiarly different about an actual full confession to a law enforcement officer that is not captured by ambiguous statements and phone calls and things of that nature. To say that a confession is harmless in this situation, I think, is a stretch too far. But I'd like to really get to this directed verdict with my limited time. I 100% agree that the definition of a felony is a question of law for the judge to determine. The judge determines the definition of a felony for this purpose the same way as the judge determines the definition of materiality in Gaudin and as dwelling house in my previous example. The issue is that the jury has to connect the dots, not the judge. The judge gets to decide the definition of felony. The jury can't say, we think felony means something different than 1 year in prison. They're not empowered to do that. But they are required to make the fact-finding of connecting the law to the facts. And that is what's absent when you have a directed verdict situation. It has long been the law that the judge cannot tell the jury that such and such is an element of the crime, but you don't need to worry about it because I've found it for you. Now, if there are any other questions, I rest.
Thank you. Any other questions? If not, this case will be submitted.
Thank you, Your Honor.
If the clerk would mute the mic.
All right, counsel, you will notice that we've installed plexiglass on the bench, so the justices are able to remove their masks. They are also distanced from the rest of us in the courtroom. We've also installed plexiglass on counsel table, so when you approach the podium, if you choose to remove your mask, you may do so and put the microphone cover on the microphone. There is a clock to the left of the podium so that you can self-monitor your time for oral argument. You each have 20 minutes to present your oral argument. For the petitioner, that includes your rebuttal time. You don't need to specially reserve it. Just please self-monitor your time to leave yourself a few minutes. With that, I will call the third case for oral argument. State of West Virginia versus Jeffrey Allen Snyder, docket number 19-0428, an appeal from the Circuit Court of Roane County. Counsel, you may begin.
Good morning, counsel.
Good morning, Your Honor. Excuse me. Your Honor, if I may, my name is Clint Smith. I represent the petitioner in this matter, Jeffrey Snyder. Your Honors, the situation here is that on March 27, 2018, the sheriff of Roane County came to Mr. Snyder's house for the purpose of serving an emergency domestic violence order, which, if the court will permit, I will refer to as it.
That's the first one. That's the one that's issued by the magistrate. It's not the one that is confirmed later on by the family court. The one that was issued the day that the sheriff went there was the emergency order.
That is correct.
Okay, thank you.
This is the emergency order, and for, if the court will permit, for convenience sake, I'm going to refer to it as a DVO, not the whole thing. He was there to serve the DVO. As the rules applicable to all of this situation indicate, serving a paper means handing it to the person who is supposed to receive it. When they did it, when they arrived there, Sheriff Cole testified before he even got out of his car, it was his intention to search Mr. Snyder's house everywhere a gun as small as 2 inches could be. And I will remind the court, of course, that the law is that anybody who is a respondent in a DVO cannot possess a firearm or ammunition, and the paperwork, the actual order itself, reflects that and says that the respondent is not allowed to possess a firearm or ammunition.
In fact, it says he has to surrender them, right?
It does. That is one of the boxes that the magistrate can check. If there is an indication of the presence of a firearm, then you go to that part of the order. I would suggest to the court that the fact that there has to be testimony in the petition about a firearm before that is checked is not relevant, because the law still is that whether that's checked or not, a respondent cannot possess a firearm. So anyway, before Sheriff Cole was going to even get out of his car, it's his testimony he intends to search that whole house for anywhere a gun as small as 2 inches could be. I would suggest to the court that means everywhere. I mean, it's 2 inches is that. He also admitted in his testimony there were no exigent circumstances. He was not in hot pursuit. He did not have a search warrant. There was no public safety incident going on. That his sole justification for his intention to search this house was his belief that the DVO ordered him to go in, search the house, and seize all weapons, all firearms. I would suggest to the court that he is wrong in that interpretation. An examination of the order itself says that the respondent shall surrender. It does not tell the sheriff to do anything. It does authorize the sheriff or the law enforcement officer to receive the firearms, because under normal circumstances, you just can't walk up and hand a law enforcement officer a gun and say, here, you hang on to this.
Walk me through the sequence of events. You haven't mentioned yet the fact that the ex-wife said there were guns in the house, and also that the respondent here was potentially using meth. So law enforcement, it's my understanding, when they arrived, they were told there are guns on the premises and drugs use may be occurring. Assuming your argument that there's the ability to demand that be surrendered but not to do the search, how could a search have been done legally under these facts, if at all?
Under these circumstances, it couldn't, because there's no evidence of a crime. Possessing the firearms is not a crime until the order is served, and then the respondent refuses or fails to divest himself of the guns. At that point, then you have a crime.
Well, that's my question, is at the point that the guns were not surrendered, but law enforcement has been put on notice that there are guns present, what should law enforcement have done to ensure the seizure or surrender, rather, of the weapons?
Your Honor, what I would suggest to the court should have happened is you hand the paper to the respondent. You say, you have to give me all of your guns, and then the duty is on the respondent, per the order, to produce and hand over all of the firearms. The order, neither the order nor the law puts any burden on the sheriff or the law enforcement officer to actually go in and make sure that that's what happens. And I think that touches on what we really have as the problem, or one of the problems with what went on here. If you put that burden on the law enforcement officer, or you give them that opportunity, that means every DVO becomes a general search warrant. Because every time one is issued and it handed to the respondent, then the officer has the ability to go in and say, I'm going to search everywhere in this house where a gun could be. And it becomes a complete general search warrant, general warrant. And then, too, if you look at it from the perspective of, which we have to acknowledge, it's not just actual possession of a firearm, it includes constructive possession of the firearm. So then you have to look at everywhere, that opens up the respondent to being searched everywhere a gun could constructively be in his possession. You're looking at searching his car, searching his outbuildings, searching his property. If he works away from his house, you're looking at searching his office. If he works in a different kind of job site, you're looking at searching his locker. I mean, it's a complete search everywhere associated with this respondent situation. And we do get into, and I think you've touched on it a little bit, this idea of the police officer's safety and everything like that. And I will agree that if this case was a situation where Sheriff Cole testified, Snyder told me he had guns in his gun safe, I was walking with him to the gun safe to make sure he didn't whip one out and shoot me, and then I saw whatever, we would be in a different situation to a certain extent. But even then, now you have law enforcement in the house. He's in the house. Does that mean that he and fellow officers can do a protective sweep through the house? Does that mean that he can do a pat down of everybody in the house? Does that mean he still can search everywhere in the house that a 2-inch gun could be, because Snyder could be lying and he could really have a gun in his sock drawer and pull it out? The real problem and the real issue with what we have here and what was proposed by Sheriff Cole is you're transforming a DVO which was issued without any of the safeguards that are built into the issuance of a search warrant into a general warrant. Go anywhere and look in anything for anything.
It's an ex parte order.
It is, and that is another issue. It's an ex parte order. And then also you run into the situation where we have here, when there was the final hearing, the petitioner didn't show up. So none of this was ever put to the test, and you have that. And I would suggest too that when you're talking about a search warrant, it's a one and done. You take it, you go to a specific place, and you look in specific locations for specific evidence of specific crimes. And all of this has to be laid out in an affidavit. The affiant has to be either inherently credible because they're a police officer, or because there's some indicia of reliability because they're a CO, a confidential informant who has given truthful information in the past and everything like that. The real issue here, though, is that under this, if this situation is allowed to continue, then you're transforming a DVO, which is issued under different circumstances for different purposes, into a general search warrant.
Did the fact that the sheriff had an emergency protective order to serve, does that give him any ability to actually enter the house?
I would say no. I mean, I suppose if he saw a respondent refusing to accept it by walking back through the house or something like that, I suppose you could run them down and put it in her hand or something like that. But no, under the rules of criminal procedure and civil procedure, it's just handed to them. You don't chase them down and put it in their pocket or anything like that. So I would suggest to the court, no, that this order doesn't authorize, or any procedure authorizes the law enforcement to go in the house at any time for anything. Now, again, if we had the circumstance where Snyder says, I've got guns in my gun safe, and I walked him to the gun safe to make sure, we'd be in a different situation. But here's the thing about all of this. We don't have to go there, because Cole never said, I went in the house because I was afraid Snyder was going to pull out a gun and shoot me, or he was going to go back into the house and arm himself and come back out and attack us. He said, I went in, I intended, before I even got out of the car, to search all of this because I had an order telling me to go in and search this house and seize all of the firearms, which was false. The order does not do that. The order does not give that authority, does not direct that a law enforcement officer do that.
And based on that fairly clear testimony about the law enforcement officer's beliefs that he could enter and seize guns, that pretty much undermines any possibility of an argument that there is a constitutionally permitted warrantless search in this situation, right?
Not only that, Judge or Justice, I went through and ticked off all of them. And I said, you did not have an arrest warrant. You did not have a search warrant. There was not exigent circumstances. And he was very forthright and happy to say no, and just went through. And not only, Your Honor, did I ask him that once, I asked him twice when he was in his car getting ready to get out of the car, and again right before he stepped across the threshold. I went through it all again, and he very happily and cheerfully said he didn't have anything that is a legally recognized exception to a warrant requirement. He was going to go in because he interpreted this DVO as ordering him to go in and search and seize every weapon. And he he wasn't disingenuous or backward about it at all. He chucked it right up there, so to speak. And so, Your Honor, again, I don't believe that there was any justification or legal recognition of anything in this case that would have allowed this search to have gone. He should not have gone into the house. And I would also suggest to you that although the respondent here is arguing safety of the police officer exception or asking you to create one of those, I would suggest to you, you don't have to go there, because that is not the evidence, that is not the facts of this case. That is not what happened. And I would suggest to the court that you might want to save that for another day, because that is a huge can of worms in terms of, okay, if you're doing, like I said, you're going to the gun safe, does that mean you can go upstairs and do a sweep? Does that mean you can pat everybody? I mean, it's just a huge can of worms, and I would suggest to the court that the court save that for a different day when those are the facts of the case, and not where you have a situation where the officer just plainly misunderstood the paperwork and the order and the law and did what he was not allowed to do.
Counsel, even though I know that here's that the evidence is that he felt he could go in simply because he had the order, but what about there seems to be some factual issues here about that they smelled marijuana and that some of the marijuana was in plain view. How would that not give them probable cause to move forward on this?
Because neither of those things happened until he was already inside. I mean, the violation occurred when he crossed the threshold. And the testimony, again, was clear. He did not smell the marijuana, allegedly, until he was already inside. And the alleged plain view contraband was located in the sweep, the safety sweep of the house, when they were already inside. And you can't, obviously, you can't say the search was good because we found stuff. The search has to be good when you go in, when you cross the threshold of the searched place. That's another thing that the respondent here in this court is doing, is trying to justify the action by saying, the search was good because we found stuff. And that you can't do that. The search has to be good when law enforcement steps across the threshold.
Is there any testimony that your client denied the sheriff access to the house? I know that there appears to have been some testimony that the sheriff asked to come in. Did your client say, no, wait a minute, you can't come in?
Your Honor, I know that is mentioned in the respondent's reply or response, that he gave consent. That suggestion comes from what was put in the search warrant application affidavit. That was not the testimony offered in the suppression hearing. In the suppression hearing, the officer said that Mr. Snyder was not given the opportunity to deny them access, and plainly said if he had said no, we would have ignored it and come in anyway.
May I come in as I'm coming in, right?
Yes, just right. Kind of sort of if he said, may I come in? I don't know. There's no testimony that he even said that. He just came in.
That comes from the warrant application.
The suggestion that they asked, and he said even in the search warrant affidavit, they don't say that Snyder said okay. They just said we asked, and they don't say that he consented. They just said they asked.
And there's also no evidence that he said don't come in.
No. And the testimony, the actual testimony in the suppression hearing was that he wasn't given the opportunity, and if he had said no, they were going to ignore it and come in anyway.
Thank you, Counsel.
Thank you.
Thank you.
Understand? Good morning.
Good morning. Thank you, Mr. Chief Justice, and may it please the court. My name is Jessica Lee, and I represent the state of West Virginia in this matter. While there may be great concern about the general reach of the service of a domestic violence protection order, we agree with petitioners that this court does not have to reach that question here, because the search and seizure of evidence in this case did not occur purely pursuant to Sheriff Cole's intentions with service of the order, but pursuant to long-established exceptions to the warrant requirement. And thus, we would ask that this court affirm the circuit court's denial of Mr. Snyder's motion to suppress.
Counsel, before you've clearly set up that you're going to focus on the exceptions. On the threshold question that is suggested here, what is the position of the Attorney General with regard to the scope of the ability to conduct a search on an EPO?
We are focusing on specifically with the argument stated in page 10 of our brief that there was implied consent here to cross the threshold into Mr. Snyder's residence. While Sheriff Cole did not testify during the suppression hearing that he asked, if you look on pages 141, 162, and 167 of the record, which are part of the criminal complaint and the search warrant affidavit, which of course was written closer to the incident, Sheriff Cole stated that he asked petitioner if he could enter the residence. Petitioner did not stop Sheriff Cole. He did not say no in response. On a page 141, Sheriff Cole noted that they walked into the house, crossed the threshold with Mr. Snyder. And so based on this court's standard in State v. Flippo, there was implied consent because a reasonable officer would have construed Mr. Snyder's actions as implying that they could cross the threshold. The 11th and the 6th Circuits have found that similar actions on behalf of a defendant indicate implied consent. For example, in United States v. Carter, the 6th Circuit found that there was implied consent where the officer asked to come in and the occupant stepped back and allowed the officer to enter the residence. Similarly, in Gill, a friend of KCR v. Judd, the 11th Circuit found that a lack of objection, while not alone, under the circumstances of also allowing the officers to cross the threshold, was implied consent, and that a reasonable officer would have construed those actions to mean that they could cross the threshold into the house.
Aren't you trying to stack one exception on another exception? Because, okay, you're saying there's an implied consent for him to cross the threshold, but when he got inside, nothing was in plain view from where he was, right? They found the in plain sight marijuana when they were doing a sweep or a clearing of the house, right?
That is correct, Your Honor, but once Sheriff Cole entered the residence, he smelled marijuana, and at that point he had reason to believe that there was a crime being committed. He saw someone coming down the stairs and heard someone walking above him. He also had knowledge that there were firearms, or likely firearms, in the residence. So at that point, Sheriff Cole was justified in doing a protective sweep of the residence to protect the safety of himself and his officers.
Do you agree with the petitioner here that all of that occurred after he stepped into the house?
Yes, Your Honor, we do agree that that occurred after he was lawfully in the residence pursuant to implied consent.
And so what exception to the warrantless, or what exception to the warrant requirement are you citing for him to step into that house? Or are you relying entirely on the consent, the federal cases that you cited?
We're relying on implied consent, and in State v. Flippo, this court said that consent can be implied from the circumstances, and once that implied consent is found in place, then a search of the residence or entrance to the residence is lawful. And that is exactly what happened here. Once he had implied consent to enter the residence, he smelled the marijuana, and then I won't repeat all of what I said, but he had reason to fear for the safety of himself and his officers, knowing that there are firearms and that there were drugs being used within the home. So he did do a protective sweep, which this court in State v. Ott, under similar circumstances, found was appropriate. There too, the officer smelled marijuana and went into the residence to secure the residence and the evidence, and that is similar to what happened here. Upon doing the protective sweep, Sheriff Cole patted down Mr. Snyder, and that's where he recovered the bag of methamphetamine. Also, he went upstairs to secure the third person that he heard walking around in the residence, and after she was secured, he did a final protective sweep of the home before going to get a search warrant. During this protective sweep, he found several items within plain view that were seized in this case. In the hallway and doing the protective sweep of the basement, he found a 5-gallon container full of what he instantly recognized as green marijuana based on his nearly 30 years of experience as a law enforcement officer. He also found in the basement the materials that he knew to be common to a home marijuana growth operation. After finding these items, he secured, the other officers stayed in the residence to secure it, and then he went back to secure a search warrant. That search warrant was justified by probable cause. He described in the search warrant affidavit all of the actions that I described to you, and then the specific items to be seized underneath the search warrant.
Counsel, just so I'm clear, you're staking your flag on the implied consent at the outset. Exactly what were the actions of this individual that met the implied consent threshold?
Well, after being asked by Sheriff Cole if he could enter the residence,
Did he say yes or no?
He did not say no, but the case law establishes that in State v. Flippo that he did not have to verbally say you could come in or any other verbal indication that the officers could enter the residence. That consent can be implied from the actions, and the actions that he did here, he did not say no in responding. He allowed them to come in the residence. He did not stop them. Mr. Snyder states that he was not given a chance, but that was not the testimony in the record. Mr. Snyder's counsel below asked if he had said no, would you have come in anyway? In response, Sheriff Cole stated, I don't believe he could have said no. So it's purely hypothetical. It's not actually what happened. What happened was that Mr. Snyder did not say no. He allowed officers to walk into the home. He did not act in any other way that a reasonable person would have acted if they did not want the officers to enter the residence.
So let me, as I review the record, the argument below was not at all about implied consent by the state. In fact, it was all about the language of the order. Is that true?
That is correct. The suppression hearing was focused entirely on the domestic violence protection order, but that does not preclude the other evidence on the record as a whole that Sheriff Cole did ask to come in.
And so while one might pick and choose portions of the testimony at the suppression hearing to support or defeat an argument about complied as consent. In fact, that was not the subject of any of the questioning, right? I mean, the questions didn't have anything to do with implied consent at the suppression hearing.
That is correct. Neither side asked questions on implied consent because they were focused on the domestic violence protection order.
And so what is a defendant to do in these circumstances when a law enforcement officer, well-intended but mistaken in my view, one opinion only, charges into a house? Is the defendant, in order to defeat some kind of implied consent argument later, supposed to obstruct justice? What is?
Well, the evidence here, Your Honor, is not that Sheriff Cole and his officers charged in. If you look at page 141 of the criminal complaint, Sheriff Cole states that he walked through the door with Mr. Snyder, or some other indication that Mr. Snyder stepped back. So if a defendant did not want officers to come in, they could say no. They could physically indicate that officers could not come in by not clearing the doorway. That was one of the reasons that the Sixth Circuit found that there was implied consent, was because the defendant in that case cleared a path by moving aside for officers to come in.
In the Sixth Circuit case, did it involve the service of a civil order?
I'm not sure, Your Honor. I know it may have just been a knock and talk by officers, and they asked if they could enter. But I'm sorry, I do not remember the exact facts on why the officers were there.
That's okay. Thank you.
Counsel, isn't this, as Justice Walker points out, hasn't the state just shifted? The battleground was on whether or not a search was allowed with the under the evidence with the EPO. And doesn't the state now basically concede that that argument of authority under an EPO to conduct the search is not well-founded, and that you've now shifted to, let's focus just on the implied consent, and you filed a brief, not a full brief. So am I right to interpret that you've decided not to pursue the search authority under an EPO because you're effectively conceding that no such authority exists?
We are definitely focusing on the alternative argument in our brief on page 10 that the officers were lawfully in the residence because they had implied consent. We recognize that the domestic violence protection order itself does not state that officers can enter and search a residence. We also acknowledge that this court has never found as an exception to the warrant requirement that officers could do so. We also note that a couple of days ago, the United States Supreme Court granted oral argument on whether officers pursuant to the community caretaker exception could do something similar by entering a residence and seizing guns because they feared that the person in the residence would use them to commit suicide under a similar theory that the state took in their brief. So we recognize that this is a significantly unsettled part of the law, so we're asking for this court to affirm based on the alternative long-established exception and to not create a new exception to the warrant requirement.
Counsel, going to the point raised by both Justice Jenkins and Justice Walker, it seems to me when you look at the October 9th, 2018 order, that the circuit court talked a little about the protective order or the domestic violence protective order, but didn't say that they were basing their finding that this was a proper search on that. They simply said the court finds law enforcement was legally in the home of the defendant when a strong odor of marijuana was observed and a bucket of green marijuana was observed in plain view during a protective sweep of the home. Isn't this, I mean, would it not be appropriate for this to be remanded to the circuit court to make a determination as to why that was proper? In other words, you know, they're saying on one hand that was proper because of the protective order, and you're arguing it was proper because of the ability to, you know, the plain view and the permission, the implied permission. But the court really didn't find either of those, did it? So isn't this something that really we need a determination from the circuit court as to what the basis was?
Yes, Your Honor, and the state does not oppose a remand in this matter for the circuit court to make a finding in the first instance of whether there factually was consent in this case, and to make a credibility determination of what on Sheriff Cole's testimony. So we do not oppose a remand in this matter. We would actually point to the Fifth Circuit, who recently did this last June, when the district court in that case made an erroneous legal conclusion on the search. The Fifth Circuit remanded so that they could make a determination based on the legally available options for the motion to suppress in that case. And we do recognize that this court has previously remanded back to the circuit court to make factual findings that they did not make in the first instance. So to conclude, we do not oppose a remand in this matter. We do believe that based on the full record in this case, that this court could find that there was implied consent to enter the residence, and thus, because officers were lawfully in the residence, they had a right. Once they smelled marijuana, they had a right to do a protective sweep, and the rest of the items were found in plain view and seized pursuant to a valid issued warrant in this case. And thus, that we would ask that the court affirm the circuit court's denial or remand for the circuit court to make that factual finding in the first instance. Thank you.
Thank you, counsel.
Your Honors, just briefly, if I may, I would agree with Justice Jenkins that the state here it's a completely moving target as to exactly why this search was proper. But I would also suggest to you that all you have to do is look at the evidence, the actual evidence, actual testimony that was had in the suppression hearing to resolve all of this. The argument now is that there was some form of implied consent for this search, and because of that, it's proper. There is no evidence in the record whatsoever that would support that. You couldn't, or you wouldn't normally. The affidavit from the application for the search warrant was not admitted in the suppression hearing. The officer did not testify that I asked if I could come in. The officer did not testify that he stepped back, or he moved aside, or he cleared a path, or he did anything that anybody could look at that testimony and say this was implied consent. There is no evidence of that whatsoever.
And the record wasn't developed as such because the state wasn't proffering that as the authority to enter the house.
Exactly. That was never mentioned as the justification or excuse for the justification for the search. The whole time below, it was because I've got a DVO, and the DVO says I can go in and search everywhere I want. And for the state to come in and create a thing out of an excuse or a justification out of whole cloth is just not proper, and is not supported by the evidence that here in this case. The whole thing below was he thought he had an order that told him to go in. He didn't try to justify it in any other way. He didn't testify that would imply there was some other reason why he could have done it, even if he was wrong on the order. And I agree with Justice Walker. The idea that he was supposed to physically prevent them from coming in, or stand in the way, or be, that's how you get hurt. That's how somebody gets hurt anyway. And let's also keep in mind, I believe the record reflects that it wasn't just Sheriff Cole there. My recollection, and if it's not in the record or in the transcript, I apologize, but it's my recollection that Sheriff Cole testified that there was at least one trooper, and I think two troopers that had come with him to serve this and conduct this search. So to suggest that a man opens his door and he's confronted with the sheriff, law enforcement is law enforcement, but not a deputy, but the sheriff and multiple state troopers, and he's supposed to say, no, I'm going to prevent you from coming in at his own peril is not appropriate.
I think your time is about expired unless there's other questions. You can
Can we
make.
just real quickly, I guess the thing is still I'm kind of having a hard time getting over is the fact that the circuit court did not say in its order what the basis of finding that law enforcement was legally in the home was. Yes, you're arguing what was all about the protective order, but yet my understanding is there at least was some testimony about how the officer entered the home, which could have given rise to a finding of implied consent, but neither one is actually set forth in this order as to why they were lawfully in the home. It's just a finding that they were. And wouldn't it be proper for us to remand this for that determination to be made?
Your Honor, I would disagree, probably not surprisingly.
Why you disagree? Yes.
Because this court would remand if there was testimony or evidence that it could have been this or it could have been that, or this would have been a proper justification, but this one's not, or something of that nature. You remand if there's something to be cleared up. In this case, there is nothing to be cleared up because there is nothing in the record below that supports a finding that they were lawfully in the house. There was, and the state sometimes is conceding there is no lawful justification for them to go in the house. The argument that they're making here is something that they have, with due respect to counsel, created. It's not in the record. There is no evidence to support it. And there is no evidence that he thought he could come in because Mr. Snyder consented, implied or directly. There is no ambiguity. I would suggest to the court there is no ambiguity in the testimony. The testimony is clear.
Anything further? I think we understand. Thank you
Thank
very
you,
much.
Honor.
And this case will be submitted.
Good afternoon, Council. You will notice that we have installed plexiglass on the bench, so the justices are able to remove their masks for questioning of counsel. They are also appropriately distanced from the rest of us here in the courtroom. We also have installed plexiglass on the counsel table, so if you choose, when you approach the microphone, you may remove your mask and put the microphone cover on the microphone. I will also remind counsel that you each side has 10 minutes to present your oral argument. There is a clock to the left of the podium on the table for you to self-monitor that 10 minutes. The respondents will be splitting that 10 minutes. The petitioner is entitled to open and close the oral argument, but just please reserve some of your 10 minutes in order to do that. With that, Metro Tri-State Inc. versus the PSC, docket number 20-0766. Counsel for the petitioner, you may proceed.
Good afternoon, counsel.
Thank you, Your Honor. The court. My name is David Hanna. I'm representing Metro Tri-State Inc., which is the petitioner in this case. I would like to reserve 3 minutes for rebuttal. We're here on appeal from the Public Service Commission order that was entered September 4th, 2020. That was denying Metro's exceptions to an ALJ decision. And that was a 2-1 decision by the Public Service Commission, which is a little rare. I was looking that up. That was the first there's a dissenting opinion by the chairman, Charlotte Lane, as the first one since 2013. So it's a little unique. And the majority opinion determined that the permitting requirements for community pastor care responded. Operation as a service, disabled, veteran-owned small business under contract with the Huntington VA Medical Center are preempted by federal law. And occasionally I may use an acronym for that. It's a kind of a long one, SDVOSB, throughout this argument. 10 days after the majority opinion, Chairman Lane issued a dissenting opinion disagreeing with the majority opinion that implied conflict preemption applies in the case. 3 points that I wanted to make. One, the majority opinion's inferences and conclusions contrary to the plain reading of the federal regulations regarding licensing requirements of the SDVOSBs and the VA's own bidding documents. The second was looking at congressional intent in this case in order to find implied conflict preemption. Congress could not possibly have intended for an additional contracting opportunity for an SDVOSB to have such a detrimental impact and impairment on the public services available to West Virginia veterans and other disabled citizens. And there's testimony at the hearing that I'm going to briefly summarize in the case showing that impact to the citizens by CPC having this contract. The third point is with respect to requested relief. Metro is asking the court to reverse the majority opinion commission order only to the extent that it applies to the interstate transportation of passengers by CPC. Regardless of the decision of this court, CPC may continue the interstate transportation of passengers under the VA contract without any authority from the commission. The contract in this case through the Huntington VA Medical Center covers the main Huntington VA Medical Center as well as 4 smaller clinics, 2 of which are in West Virginia. One is here in Charleston, one is in Lenore, West Virginia. There is also one in Prestonsburg, Kentucky, as well as one in Gallipolis, Ohio. There was Jamie Marlowe, the president of Metro Tri-State, testified at the hearing before the ALJ at the commission that approximately 90% of this contract is performed wholly within West Virginia. transportation to and from the main Huntington VA Medical Center. So there's a very small percentage that is actually interstate. But certainly those interstate trips or travels would not be subject to PSE jurisdiction as the law still sits. Moving to the first point about the regulations and the qualification of bidders in the documents in this case, there's two quotes. One, the firm, the CFR regulation states that a firm must obtain and keep current any and all required permits, licenses, and charters required to operate the business. The second is paragraph 12A of the qualification of bidders in the VA's own bidding documents for this contract stated that a successful bidder shall meet all requirements of federal, state, or city codes regarding operation of vehicles required for this contract. And in West Virginia, a contract carrier, such as what CPC is performing, in this case, is required to have a permit issued by the Commission. And the CFR, as well as the qualification of bidding document, states all requirements must be complied with, not some. And I will add that it was in the briefing, but Metro Tristate was performing this contract prior to CPC being awarded the contract. And the whole purpose of this contract is to operate vehicles for hire in the transportation of passengers, which does require a permit or certificate from the Commission to the extent the transportation is intrastate. I want to address the Supreme Court of Appeals of West Virginia decision, Morgan v. Ford Motor Company, about the law has a bias against preemption. And in this case, this is an area of regulation that is traditionally left to the states, which is regulation of the interstate transportation of passengers for hire by a motor carrier. And in that case, there should be, there's a high bar to meet, and that the preemption is disfavored in this case because of that area of traditional regulation by the states. Now, while the federal government may be required to give preferential treatment in awarding certain contracts to service disabled veteran-owned small businesses, such preference does not expressly or impliedly exempt such businesses in complying with state licensing requirements, just simply because they are owned by a service-disabled veteran. What I alluded to earlier about Congress could not have intended for an additional contracting opportunity for a SDV-OSB to have such a detrimental impact and impairment on the public services available to West Virginia veterans and other disabled citizens. There was testimony by Mr. Marlowe that he had provided transportation services to the VA for over 30 years. They nearly 2015 to 2018, Metro averaged nearly $500,000 in annual revenue from serving the VA. That's representing more than 50% of Metro's total annual gross revenue. The loss to Metro is not simply a decrease in their profit margin. What happens is it's a loss of services available to the disabled citizens of West Virginia, including veterans. What Mr. Marlowe's testimony stated was that in serving the VA under the contract, it allowed Metro to not only better serve the general public, but also provide transportation for veterans that did not qualify for the program paid for under the contract with the VA. They had vans for wheelchair transportation to the general public, including veterans. But without the VA contract, Metro couldn't sustain the number of vehicles to provide wheelchair transportation to the general public. So if there are certain rides that they may not be able to make anymore for these individuals because of the loss of this contract. So that's going to be a detrimental impact, and has been, to the citizens of West Virginia, certainly in the Cabell and Wayne County area, which is where Metro Tristate has authority to operate.
Council, you have a little less than 3 minutes left. If you would like to reserve any time, you better do so.
Okay, I will be brief in my last comment. But what I wanted to say is the third point was that there was the CPC's brief was I wanted to make clear that this contract is approximately 90% intrastate transportation. The court could reverse the PSC, send it back for determination with respect to the contract carrier permit application, which was a case that was also consolidated and was pending before the PSC, which they didn't make a determination under because of the finding a lack of jurisdiction in the case. But the same goal or of having opportunities for service-disabled, veteran-owned small businesses could still be present even if the court reversed the PSC, because there's still that interstate portion of the contract that could be performed without needing any state licensing or state certification from the PSC. However, the overwhelming majority of the contract is interstate in nature. Thank you.
Thank you, counsel.
Your Honors, may it please the court, I am Robert Adkins and I'm representing the Public Service Commission in this matter. Counsel for Community Pastor Care, Bob Pruitt, and I have agreed to split our time with 5 minutes apiece. In the Morgan case, this court held that implied conflict preemption occurs when state regulation poses an obstacle to the accomplishment or execution of federal objectives. The state permitting requirements clearly pose an obstacle to the objectives of the Veterans Benefit Act here in this case. The federal objective or the congressional intent here is clearly stated in the first sentence of the act: to increase contracting opportunities for small businesses owned by veterans. The act establishes a federal framework for a federal agency to contract with veterans to transport veterans at no charge to VA hospitals. This is totally within the sphere of federal operations. The federal government pays for the service through contracts specifically set aside for this purpose. This is basically a federal hospital shuttle service paid for by the federal government.
Counsel, let me just ask you on the question of the intent of Congress in this case. If the intent of Congress appears to be that to encourage, as you said, veteran-owned businesses to have this business, but it's not really intended to necessarily cause competition among those, which seems to be a different purpose. That if that were the purpose, then I could see where the PSC regulation that requires a certificate of need, looks at where there's an existing need, would be contrary. But can't those two coexist?
Well, we don't think they can coexist, because if you require the veteran-owned businesses to be subjected to state permitting requirements, it can be very difficult for them to meet the contract carrier requirements in 24A33 of the West Virginia Code. The code requires these contract carriers to prove that they will not negatively influence or impair existing common carriers that are operating in the same territory. And that's proven to be a very high burden for these applicants, such as Community Pastor Care would be if they had to get a permit. It would be a very high burden for them to meet, especially if it's a protested case. Protesting common carriers can litigate these cases and create an issue and convince the commission that the contract carrier applicant will impair their service, and that happens frequently. I've cited cases in our brief that show that. So I think it would be hard for this, like say, to coexist without impairing or frustrating the objective of Congress to increase contracting opportunities for these veteran businesses.
What if the company that already has the contract is a veteran-owned business and fulfills the purpose of the congressional enactment, and someone challenging that isn't? Then by not allowing the certificate of need process to go forward, aren't you actually kind of going contrary to the statute?
Well, and the commission addressed that in its order. The commission narrowed the scope to say that this only applies, this exemption or this preemption only applies if the carrier is a veteran-owned small business. It doesn't apply to just any contract carrier that's trying to get a contract with the VA.
Thank you.
I was going to go on. In fact, the Veterans Benefit Act restricts competition for contracts if two or more qualified businesses submit bids. It's called the rule of two. in the Veterans Benefit Act. So clearly, Congress intended to increase the number of veteran-owned businesses contracting with the VA. Now, I've already gone on, I've discussed how the 24A33 presents this obstacle to the operation of this federal framework. And in the Weirton case, the Weirton, Ice, and Cole case, which we cite in our brief, this court stated that there is a significant difference in the showing of need that is required of a common carrier and the contract carrier's burden of showing need, and that the proposed service will not be a negative influence on other carriers. Now, Metro contends that there's no conflict between the state regulation and the objectives of the Veterans Benefit Act because the Act allows the VA to hire non-veteran businesses and does not mandate contracting with veteran businesses unless the rule of two applies. But simply because non-veteran businesses can be eligible does not mean that the purpose of the Act should be frustrated by requiring veteran businesses to meet the burden of state permitting requirements.
Doesn't this case, or isn't this case a lot like the U.S. versus Virginia case, the FBI case?
Yes, it is very similar to that case in that the Virginia was trying to regulate licensure of FBI agents. And
in fact, the court says the fact that the FBI had their own standards in terms of what they would require of the individual that they hired, which were different from the standards being imposed by the Virginia Private Investigation Licensure Act, I guess is what it was.
Yes.
They said that materially interfered with the federal purpose. It's pretty clear that that's the same thing that's going on here, because the VA has its own standards, and it decides who is qualified, as opposed to the PSC deciding who's qualified to meet the VA standards. Is that a fair statement?
That's a fair statement, and it like I said, as in Virginia, this would frustrate the objectives of the VA to hire who they would want to choose, and that would be a veteran-owned business.
Your time is, if you want to reserve for your other respondents, counsel, 5 minutes. Recommend that you wrap up soon.
Okay, yes, thank you. Just in conclusion, I'd like to say that in this case, the Commission was considering the congressionally stated purpose of the Veterans Benefit Act to increase contracting with veteran-owned businesses. State market entry regulation definitely does not increase those contracting opportunities for veteran-owned businesses and could very likely decrease those opportunities. Thank you.
May it please the court. My name is Bob Pruitt, and I'm pleased to be here to represent Community Pasture Care. Now, Mr. Atkins did an excellent job explaining why the state contract carrier permitting requirements are preempted in this case. Put simply, state law cannot be used to undo a business opportunity that was set aside under federal law. For my portion, I intend to focus on two things that Mr. Atkins has not already told the court. First, I'll address Metro Tri-State's argument that a regulation supports a ruling in his favor. And second, I'll address why a case cited in Community Pasture Care's brief that was addressed in Metro Tri-State's brief requires ruling in ours. So turning first to the regulation. Metro Tri-State incorrectly argues that a small business administration regulation disqualifies Community Pasture Care from taking advantage of a business opportunity that was set aside as a service-disabled veteran-owned small business under 38 United States Code 8127. That's not the case, and to be clear, that's not a call for the Public Service Commission or any other state tribunal to make. Under the following two statutes, 38 United States Code 8127 and subsections F1 and F4, as well as 38 United States Code subsection B, That call is for the United States Department of Veterans Affairs and it alone to make. Consistent with those two statutes, administrative guidance in the Federal Register makes clear that the exact regulation upon which Metro Tri-State relies is meant only to quote-unquote provide guidance as to when a business may be found to not be a service-disabled veteran-owned small business. Whatever discretion the United States Department of Veterans Affairs may have had with this matter, it vetted community pasture care under the facts of this case and found that it indeed is a service-disabled veteran-owned small business. And accordingly, it added community pasture care to its database of veteran-owned small businesses that it keeps under 38 United States Code 8127F and 8128B. So the fact remains that community pasture care is indeed a service-disabled veteran-owned small business and that it should be treated as such for the mandatory set-aside provisions under 38 United States Code 8127D. In Kingdomware, which was addressed in all the parties' briefs at length, the Supreme Court of the United States found that these set-aside provisions were mandatory and not discretionary. To the extent Metro Tri-State tries to use a regulation to get around those mandatory provisions, the Supreme Court in Kingdomware discarded such an argument by simply stating that it will not defer to administrative guidance when the statute 38 United States Code 8127D is unambiguous. This court should follow suit and reject Metro Tri-State's argument. Turning to the case that Metro Tri-State addresses in its reply brief, Lafferty. It's the only case they address. In that case, Metro Tri-State makes some presumptions about the facts of the case, and it attempts to make some distinctions without a difference. To be clear, the court in Lafferty did not rely on any of those distinctions, such as whether JanCare provided services across state lines. The Lafferty court's analysis was simply this. A, the Huntington VA, the same VA that is at issue in this case, is a federal entity, and it selected JanCare for its service provider of medical transportation services. B, applying Kentucky's Certificate of Need and licensure laws might supplant the decision of the Huntington VA for that of the state of Kentucky. And as a result, this in and of itself would obstruct the VA's objectives and was enough to find that the state licensure and Certificate of Need laws were preempted without regards to whether JanCare might have violated a contractual provision requiring it to obtain local licenses. The analysis applies here. The same VA location selected community pasture care for medical transportation services. Applying state contract carrier permitting requirements might deprive the VA of its choice and supplant it for that of the state of West Virginia. The only real difference between this case and Lafferty is that here, Metro Tri-State's request for relief would violate a federal statute, 38 United States Code 8127D, whereas in Lafferty, no such statute was at issue.
Counsel, do both your client and the petitioner meet the requirements to be considered a veteran's own business?
Your Honor, the Department of Veterans Affairs made that determination and they decided that it did, and there's been no facts presented on this record to indicate that they're not.
So if both did, the petitioner was first to get there basically, and if you take the federal law out and just apply the state law, you would be your client would be unlikely to be able to get a certificate of need. Is that fair to say? Because there was already a company providing this service.
To go to Justice Hutchison's note, this case is a lot like the U.S. versus Virginia case, which if I'm getting my cases, if I'm keeping my cases straight, that case specifically noted that there are some restrictions that might be valid under state laws that nonetheless, because of preemption principles, are not permissible, regardless of whether absent application of federal law, whether community pasture care would be entitled to the contract with the Huntington VA. The federal law nevertheless exists, and it requires that certain contracts be set aside for veteran-owned small businesses. Community pasture care qualifies as an SDOV OSB. Metro Tri-State does not. Therefore, under the contracting preferences under 38 United States Code 8127H, the contract has to go to community pastor care.
Counsel, your time is about expired. If you'd like to summarize, we would appreciate it.
Thank you, Your Honor. That's all.
Great. Thank you. For the petitioner, you have a little over 2 minutes left if you'd like to offer any rebuttal.
We don't count microphone covers toward your time, so you're good.
Thank you. I just wanted to briefly address that Lafferty case, the case out of the Intermediate Appellate Court in Kentucky. I think there are some similarities in the case. It does involve the same Huntington VA. We are talking about an ambulatory transportation service, and one of the big differences is with the language in that contract. There was I think the 2005 contract, which was the prior contract to the one at issue in that case, included requirements that the holder of that contract have licensure in all the states that it's providing service in. And as the change in the 2012 contract that was at issue included a state-specific requirement for licensure in West Virginia, but no specific requirement for Kentucky licensure. And that was a term that varied from the prior 2005 contract. In this case, the CPC's contract doesn't limit the states in which CPC must have licensure and does not relinquish the requirement of complying with state laws. And I'll point out that JanCare, the ambulance company that was at issue in the Kentucky case, Lafferty, did have authority in West Virginia. Now, under its prior contract, it subcontracted out any trips that it had in Kentucky, but that changed with the 2012 contract, where it no longer felt that it needed to do that because of the change of the language of the contract.
So it's the change in the language of a contract with a federal entity. And in the Lafferty case, it says, Kentucky requiring licensure is interfering with the federal agency's right to pick who, decide who's qualified for the contract. Doesn't that apply equally here?
I think it's different in this case because we have an area that's traditionally left to the states to regulate the interstate transportation of passengers for hire by motor vehicle, whereas then there's certificate of need laws for the ambulatory transportation, which is more of an emergency type transportation service as opposed to here, which is a non-emergency transportation service. So it is different in the certificate of need laws. And I think there was just some discussion in that case also about how certain certificate of need laws don't apply to federal VA hospitals when they're going to expand their facility. So I think it's different in that regard.
Anything further? If you would please wrap up, we would appreciate it.
I have nothing further. Thank you very much.
Thank you very much, counsel. This case will be submitted.
All right, counsel, for the next case, while we're transitioning at council table, I do want to let you know that we have installed plexiglass on the bench between the justices, so they are able to remove their masks so that you can better understand their questions. We have also put plexiglass on the council table, so when you approach the podium to present your argument, if you choose, you may put the microphone cover on the microphone and remove your mask to present your oral argument. As you know, your case is being argued under Rule 19. That rule provides that you each have 10 minutes to present your oral argument. Counsel, for the petitioner, that 10 minutes does include your rebuttal time, but please just self-monitor your time. We've placed a clock on council table beside the podium to the left so that you may monitor that time. With that, you may come up to council table and I will call your case. Horizon Ventures of West Virginia Incorporated versus American Bituminous Power Partners, docket number 190171,
an appeal from the Circuit Court of Marion County.
Good afternoon. My name is Mark Keppel. I'm a lawyer at Bailey & Wyant in Wheeling, and we've recently come into this Horizon versus Ambit case. This case arises from a contract that was entered into and performed for the past, say, 30 years or so. It was entered into between two sophisticated companies, and then Ambit stopped paying the contract. And we sued them, or excuse me, Horizon sued them, and Ambit moved for summary judgment and claimed that the contract that they had been performing for 30 years was unconscionable. The lower court erred when it agreed with them. The lower court erred in four principal ways. The first was when it found that the elements of unconscionability were met, in that unconscionability to void a contract requires both procedural and substantive. The lower court in paragraph 16 of the order specifically found that the parties asserted that there was no procedural unconscionability. So without procedural unconscionability, there can't be unconscionability, because that's one of the critical elements. The second topic, I guess you'd say, is the court supported its findings that there was unconscionability by saying that it didn't have a bilateral escape clause. A lot of contracts don't have a bilateral escape clause. Thirdly, the contract was perpetual, as the lower court found. That is not the case, and that ruling was also in error to support a finding of unconscionability. And lastly, the motion for summary judgment was decided while discovery was pending. So turning to each of those four items, number one, the finding of unconscionability. The case law in West Virginia has always been that you must have procedural and substantive. In this case, there simply wasn't. These are sophisticated corporate entities that performed the contract for 30 years. And then only when they breached did they assert this unconscionability piece. Paragraph 16 of the court's order is something that should be reviewed, in that it is clear and undisputed that the parties asserted that there was no procedural unconscionability. So the law in this case does not protect a corporation that enters into a contract, performs it for 30 years, in the absence of both of those findings.
Isn't West Virginia one of two states that require both procedural and substantive unconscionability? The proverbial sliding scale, isn't it West Virginia and California the only two states?
I couldn't speak to a national survey of that, but I'm very certain that West Virginia, in a long litany of cases, finds both of those.
That litany of cases started with Brown, right?
I'm sorry?
Brown versus Genesis Healthcare back in 2011, and that's the case that started all this.
I don't know if I would say that necessarily started there, because if it goes back into, I want to say maybe even probably into the 70s, when they talked about the parties' relative bargaining positions. That's essentially the procedural element of it.
But it wasn't until Brown versus Genesis Healthcare that this court came down and says you got to have both. It can be a little of one and a lot of the other, but you still got to have both. And that's a minority position nationwide, isn't it?
I can't speak to the national survey of that, Your Honor. I'm sorry about that. I don't know. But like I say, I believe that it is a fairly well-established premise that you must have both, and the courts have always focused upon there being some element of some problem with the bargaining position of the parties. And in this case, there is no dispute. There was none. And without that unfairness going into the contract formation process, you can't strike aside the contract. The next issue that's really important to understand how the lower court's ruling was wrong relates to the premise that that the contract was substantively unconscionability because there was no bilateral escape clause. Many contracts, like I said in the beginning, don't have a bilateral escape clause. For example, an oil and gas lease, as long as the oil and gas is being extracted from the ground, the lessor cannot end that contract. This contract, as long as the power was being produced, could not be ended bilaterally, on a one-sided. So that is a normal one-sided provision that shows up in a lot of commercial contracts. It also makes sense because when you have multiple clauses in a contract, maybe one is one-sided, but then the next clause isn't one-sided, or the next clause is one-sided to the other party. And that's kind of what we have here, because this contract entered into in 1987 provided for a $50,000 consulting fee. Over time, there's no increase in that. If you were to have inflationary costing of that, it would be a substantial amount more. And that is a one-sided provision that could be viewed at least that way. So when the courts look at this, they look at it in this holistic standpoint, not just this singular clause. If Ambit had wanted to provide that it needed a bilateral escape clause that the lower court placed so much emphasis on, it could have bargained for it. These were sophisticated commercial entities. They didn't bargain for it. The third issue relates to the court's premise supporting that the contract was unconscionable because it proceeded into eternity, basically, that it was a perpetual contract. Well, again, that's just factually wrong. The contract ended when the power was no longer being produced from the plant. In this case, the power purchase agreement provided that it would terminate in 2036. So at that time, the contract would end. So again, that's just simply not the law or the facts in the case. And so for that reason, the court should be overturned. Basically, what the lower court has done is changed one of the critical elements of the contract to require that there be some certain date that I guess is foreseeable into the future. That's just not what West Virginia contract law provides. Lastly, this summary judgment was entered into prior to the expiration of the discovery period. The court has indicated in numerous opinions that it is precipitous for a lower court to grant summary judgment prior to the expiration of discovery, and that's what's happened in this case. So all of these issues that I've talked about could have been discovered in more depth and provided a basis where the court would have hopefully understood that these issues were not appropriate for summary judgment. And so it's on this that we ask that the court overturn the lower court's grant of summary judgment and let us proceed along that way.
Thank you, counsel.
Thank you.
May it please the court. Roberta Green here on behalf of American Bituminous Power Partners. We appear before the court today in support of the Circuit Court of Marion County and its motion and its order granting American Bituminous Power Partners motion for summary judgment entered by Judge Wilson in January 2019. We are in support of this order on the basis that Judge Wilson clearly indicated an understanding of the law of unconscionability, understood the law relative to public policy, demonstrated a clear understanding of the procedural stance of the case and the rights and equities between the parties. However, we're pleased to have the opportunity to address this concept of procedural unconscionability. First of all, our court, or y'all, sorry, this court has determined that it is generally both procedural and substantive unconscionability. And it's been the statement of this court from Brown, even before Brown, but from Brown forward. So in Blackrock versus Fish, where this court is distinguishing between New York law and West Virginia law, this court draws the distinction that in West Virginia it's generally both, not always both. As recently as Stonerise versus Kaiser Center, which was June of last year, this court reiterated that it's a sliding scale. And the more you have of one, the less you need of the other, as the justice has suggested.
Do we have any case that says, as in the order here, where the judge said there was no procedural issue or finding? Do we, while there's a sliding scale,
yes,
do we have any case in West Virginia that says the absolute absence of either substantive or procedural, you can still find unconscionability?
Yes, actually, and you can find it as a matter of law. First of all, I would argue that there was procedural unconscionability. If you look at paragraph 6 of the findings of fact, the court identifies one of the issues pending before it was meeting of the minds. And that is reflected in the motion for summary and judgment, which is Bates stamped 102, and in our reply brief, which is Bates stamped 224. So we were putting before the court, as this court is recognized in Blackrock, that if a clause is so bad that no sane man, unless demented, would enter the contract, and no honest and fair man would accept a contract, then that clause in and of itself is the sine qua non of procedurally unconscionable. And that runs all the way through the case law. So going all the way back to Lowther versus Guffey in 1902, where this court identified a clause that is so bad it is fraud on its face. Move up through Troy Mining in 1986, where this court said that there are clauses that are so bad that they are absurd on their face and immediately constitute procedural unconscionability. Up through Blackrock, where this court found that it can be outrageous and constitute procedural unconscionability. So as a matter of law it is, even beyond the fact that in this instance there was a meeting of the minds reflected in the court's own order. Beyond that, the court also relied on mutuality. And as this court is aware, in Dan Ryan, you held that a lack of mutuality is not the same as an unjust contract. And nonetheless, in Dan Ryan versus Nelson, this court went ahead and found that throughout that contract between Dan Ryan Builders and Mr. Nelson on the lack of mutuality. So while it is not an immediate exit clause if it's not mutual, or if it is mutual, it still doesn't save the contract. In terms of the contract being perpetual, what the court found was particularly worrisome about this one is because I tried twice, actually, to resolve this as a matter of law. And Pingley is my case, so I've been here before for early filing, and I understand that. But the first time I filed, Judge Wilson told me that I didn't have the predicate for it, that there was no indication in the record that Horizon wouldn't let us out, let American Bituminous out. So it sent me out to go do discovery, and I deposed Mr. Sears, and who's the principal of Horizon, and it was his statement and his sworn testimony that he would never let Ambit out of the contract. It's supposed to be if we ask, we can agree, you let us go. And the principal of Ambit said he has a background in construction that's very typical in construction contracts. If you have changes, you speak to each other, you agree, you put it in writing. He thought it was very sane, very normal. But Mr. Sears testified under oath that he would never turn it loose. When we're talking about, it's only $50,000 a year, Ambit paid for 29 years. And as of the $50,000 that Judge Wilson had them put on file with the clerk in Marion County, that's $1.5 million. So in terms of, a little bit here, a little bit there, that's starting to be a neighborhood that's certainly got some ring to it. In terms of the discovery...
But what about the testimony of your 30B7 witness who testified that when he signed the agreement, he expected the plant to operate for approximately 35 years. Doesn't that throw a wrench?
I'm sorry?
Doesn't that throw a wrench in your argument?
When he testified?
He testified that when he signed the agreement, he expected the plant to operate for approximately 35 years.
He did, but you know what's interesting is that it's tied not to the power purchase agreement, which counsel referenced the power purchase agreement. American Bituminous owns a Granttown power plant. It has one client, that's Mon Power. And that power purchase agreement goes 35 years. However, this consulting agreement isn't tied to that 35 years. It says as long as they're producing power. So they can't even get another client and get rid of Horizon's $50,000 a year. It doesn't mean getting rid of the power purchase contract. It means you have to shut down, lock the door, or you keep paying. And it was Mr. Sears' acknowledgement of that under oath that they would never turn him loose. That was enough for Judge Wilson to move forward. Judge Wilson acknowledged there was discovery pending, there could be factual issues, but we filed the motion for protective order that is also in the certified record at 289. And in that motion, we demonstrated that every single one of their interrogatories, our 30B person had already answered at deposition. So the discovery was redundant. Everything except our pretrial materials. We hadn't disclosed those, but we weren't to trial. But every question they put in the discovery, they'd already asked our person, our main guy, at deposition. So in terms of there was pending discovery, there were hot issues, all those issues had been answered. And we detail them out with cites to where they were in the deposition of Richard Halloran and where they are in the interrogatories. So as a matter of law and fact, Judge Wilson's order is on all fours in terms of the law of unconscionability, the law of West Virginia. We believe that there was no true meeting of the minds because certainly Richard Halloran would never have entered a contract that was absolutely where they would never let him out. And as a matter of law, it is a clause.
So your position is with regard to, again, Brown and the issue of sliding scale, procedural and substantive,
yes.
With regard to unconscionability, it's your position that we should not modify Brown and eliminate the requirement to have some indication of both that proof of one is sufficient, or are you on the page that you think there was both, the record shows procedural and substantive findings to find this not unconscionable?
It's my position that as a matter of law, there really is procedural unconscionability at work here, and I believe it was proven in fact as well. And
So you have no, so you're not on the page that Brown needs to be modified?
You know, I'm amazed how Brown is so flexible and works its way through all the cases in their head notes. There's room in Brown. It's a fish to feed all hunger. You know, so I would say, if anything, under like Nolan versus Virginia Insurance, rather than throw out Brown, if anything, this order really should reflect that the judge himself found procedural unconscionability when he said that this clause is so bad, and this is what Judge Wilson found so bad, that in and of itself, it so violates public policy, it cannot be allowed to stand. It is so substantively egregious it cannot be allowed to stand. And he falls in the category of it's a clause that no sane man, unless demented, would agree to, and no honest and fair man would accept. Thank you.
Thank you, counsel. Counsel, you have just a little less than 2 minutes. If you would like to use that for rebuttal, you're welcome to do so.
Thank you.
The clerk is able to get you a new one. You've done great.
So just a quick concluding remark. the court asked the question, is there a case that says that you don't need to have procedural unconscionability? There is no case that says that, not in West Virginia. With regard to this idea that you have to have procedural unconscionability, I kind of fumbled the ball when you were asking me those questions, but it goes back to that Arts Flower case. It's a 1991 case that says you have unconscionability, you must focus on the relative bargaining positions between this. This has always been a part of our jurisprudence. There's no basis now to change that. And in Brown, it again, one of the syllabus points specifically focuses upon the existence of some procedural unconscionability. And I don't know where it gets confused here, but the order is very clear. The parties asserted that there was no procedural unconscionability. And now when we come to see you, there somehow is. There wasn't. This contract was performed for 30 years, entered into by very, very, very sophisticated people. So there's no real basis here to go ahead and excuse Ambit here from a contract that they simply don't want to honor anymore. So that concludes our position. Thank you.
Thank you, counsel. This case will be submitted. Good afternoon.
Council, you will notice that we have installed plexiglass on the bench between the justices. They are able to remove their masks due to the plexiglass separating each of them, and they are sufficiently distanced from the rest of us here in the courtroom. There is also plexiglass on counsel table, so if you choose, when you approach the podium to present your oral argument, you may put the microphone cover on the microphone that you were given and remove your mask. We have also put a clock to the left of the podium on counsel table so that you can self-monitor your time for oral argument. In this case, the petitioner is given 10 minutes to argue, the respondent is given 10 minutes, and then the intervenor is also given 10 minutes as an intervenor in the case. That 10 minutes for the petitioner includes your rebuttal time, so please self-monitor your time, saving for yourself a couple of minutes for that purpose. With that, State of West Virginia ex rel. Jeff Maynard versus James C. Justice II, Governor of the State of West Virginia. Docket number 21-0051. This case is before the court under its original jurisdiction, and counsel for the petitioner, you may proceed.
Good afternoon, counsel. You may proceed.
Good afternoon. Thank you. If necessary, I'd like to reserve at least 2 minutes for rebuttal, please. Excuse me. May it please the court, I'm John Bryan, come here from the metropolis of Union, West Virginia. And I have my 13-year-old son here with me, John Jr., today, and I appreciate you having us here and also expediting this important case. And I represent the petitioner in this case, the chairman of the Wayne County Republican Executive Committee, Jeff Maynard. Now, this is a case about ensuring that local voters in legislative districts have a say or have control over who is filled or nominated for vacancies in those legislative districts, and to ensure that they are not disenfranchised for state party bosses or state party officials. And that's not the way the law is in West Virginia, where a local committee in West Virginia pursuant to Section 310.5 has chosen and submitted 3 nominations to the governor to fill a legislative vacancy, and where they've done so within 15 days of the creation of that vacancy, the governor has no discretion in the matter. He must choose between that list of 3, and he has 5 days in which to do so. A governor may not call for a do-over. He may not wait for the state GOP or any state party to do a do-over. May not request another candidate or wait for interviews of other candidates. The undisputed facts are here that the governor was presented with a list of 3 nominees from the Wayne County Republican Executive Committee, from those members in the District 19 where the vacancy lied, and the governor failed to make a choice within the 5-day period after receiving that list of nominees. And that's what this entire case is about. The Wayne County Republican Executive Committee is the party that is entitled to clear relief in this case. It's not the state GOP. It's not the acting chairman. It's not the governor. It is the Wayne County Republican Executive Committee, because they consist of the District 19 committee members, who, as the court knows, are elected under West Virginia law for just this very purpose, to vet and to vote on candidates for the governor to choose for a legislative vacancy.
Counsel, you obviously focused on statutory provisions at 310.5, but you failed to mention anything in your brief about West Virginia Code 319 that actually talks about the delegate district and the executive committee. And I understand your point that this is a subset of the Wayne County, but why have you not set forth in your brief any reference to 319 where it actually talks about the delegate district?
That's a very good question, Chief Justice Jenkins. The original petition that we filed was against the governor, and it was very simple in our eyes. 310.5 says that the local committee gets to choose the nominees for a legislative vacancy. The governor failed to do so. Pretty simple. Then what happened? The state GOP interjected themselves into this matter and claimed that they somehow had the ability through their bylaws to inject themselves into the legislative vacancy process to give themselves what is essentially a veto and complete authoritative control over the nomination process. So I would point the court to the reply brief that I had filed in this case that extensively goes over 319, and that's exactly right. Is 319 has subsections A, B, and C, and subsection A creates and establishes, governs the state executive committee. Subsection B governs multi-county legislative districts, and which we're not dealing with here. Subsection C of 319 creates and organizes and governs county executive committees, which is exactly what we're dealing with here. So the also in 319 is, I think it's subsection G, establishes that all of these committees are separate and independent bodies with their own organization, with their own leadership structure, and that is exactly the law that shoots down the state GOP argument that they can use their bylaws to tell the state committee what they can and cannot do. Because they are separate bodies under 319, the county executive committee is not a subcommittee of the state executive committee. It's just not, and nor is it subservient as the state executive committee would like to claim, at least in their bylaws. So I think it's important to understanding the structures of these political party committees, but it still is only relevant to explaining to the governor and to the state GOP of why they're wrong and why they misunderstand the responsibilities and the limitations of the state executive committee. Because all we have to do, and I'll keep coming back to this, but all we have to do is look at 310.5. 310.5. If they don't understand the difference between the state executive committee and legislative committees and county committees, then yeah, we can get into the weeds in 319. The fact is 310.5, it is very, very clear. It's very unambiguous. The governor has 5 days to choose from a list submitted by the relevant local committee. In this case, that's the Wayne County Republican Executive Committee, because it's my understanding there are 5 magisterial districts in Wayne County, and 4 of those districts comprise District 19. And so at the time this vacancy occurred, there were 4 members of the Wayne County Republican Executive Committee who resided within District 19. And therefore, pursuant to 319, they consist of the District 19 Delegate Committee. And 310.5 says that that is who gets to choose the nomination of 3 choices for the governor to pick.
It's your position then that those members of the county executive committee who happen to live within the Delegate 19 district are automatically members of the delegate district committee?
Yes, Your Honor. According to the law, the members of the Wayne County Republican Executive Committee who were elected, or they could have been appointed to vacancies, but those electees elected at their local precinct, those are the District 19 members. So it's all it.
Where is your authority for that proposition?
Well, the authority is 319 A, B, and C, which just delineates the State Executive Committee in A, the multi-county legislative committees in B, and then the county executive committees in C.
But there's no description of an executive committee for a delegate district that is contained within a county but does not encompass the entire county.
That's right. That's right, Justice Wooten. The only authority for the creation of these committees in the first place is in 319, and it is somewhat confusing. But there are 43 districts in West Virginia, delegate districts, and there's only one Senate district, from my understanding, that resides wholly within one county. But there are 43 delegate districts that reside wholly within one county. So there is no separate executive committee for those 43 different districts. It is just a subcomponent of the county executive committee, and that's the way it's always been done. And in the supplemental appendix responding to the state GOP here, I showed the other examples that I found that were analogous to this situation.
Counsel, is there any kind of response? The suggestion has been raised that because the first letter from the county had a signature block for the chairman, Mr. Maynard, with no signature, but the subsequent letter to the governor from the state party was signed by Mr. Maynard and our Chairman Maynard, and the suggestion that maybe this is a moot issue or he is waived by acquiescing to the second letter with his signature, but not signing the first letter.
Well, I have a twofold response to that, and the first and most important is that we look at the 5-day period. So the state, the state code is just the strongest response to any of this. If we have to look at the GOP bylaws, then we've gone out of the code. So the state code says if it's served within 15 days to the governor thereafter has 5 days to choose from that list. So what happened in this particular case is day 1 went by, day 2 went by, day 3 went by. We get to day 5, and the news media is calling my client. The candidates are calling my client, who did the governor choose? Who did the governor choose? So he tries to call the governor, no answer. Leaves messages, doesn't get a call back. And finally, after the time period had expired, then he gets a call from the governor's chief of staff saying, look, something to the effect that we were contacted by the acting chair of the state party, and he says it's on the wrong letterhead, it was done wrong, and they're going to have to do it over. That's why we didn't choose.
Yeah, because your time is short. So you're basically saying the chairman signed the second letter in protest, or in?
Well, the first part of my answer is that he didn't make a choice within that 5 days, and he was mandated to do so under the law. But secondly, just to address the second letter is invalid because if you look at the affidavit of my client and then the statement of the county secretary, and the reason it's a statement and not an affidavit is because when I finally was able to get a signature from her, she was traveling and couldn't find a notary. So it is signed by her, and I believe it is what her testimony consists of. But the signatures of both Mr. Maynard and the county secretary on that second letter are very problematic because they were asked to sign this sheet of paper when the deliberations were still ongoing, and that's their testimony. So two of the individuals who were the same two who were on the first letter was Mr. Schaffer and I can't recall the other one, but the two of them were chosen relatively quickly, and then there was debate by the two committee members who showed up for the second meeting. They were still debating at the time that those signatures were applied. And I think...
I appreciate it. Your time is about expired. If you want to reserve anything for rebuttal, I recommend that you...
Yes, I'll do that. Thank you.
Thank you, Mr. Chief Justice. May it please the court. My name is Lindsay C., Solicitor General, and I'm here this afternoon on behalf of the respondent, Governor Justice. Petitioner pitches this case as a dispute between the responsibilities of the State Republican Party and the Wayne County Executive Committee. But here, the West Virginia Code leaves those precise questions to the party itself. Neither the governor nor this court should act as an intra-party mediator for disputes like these. Instead, the legal question before the court is simple. Did the governor have a non-discretionary duty to choose Derek Evans's replacement from the list submitted by the Wayne County Executive Committee? He did not. Section 3510 is clear that when a delegate vacancy arises, it's the delegate district committee that may submit the list of 3 names for consideration. So the only way petitioner can prevail here is if the letter that he talks about was submitted by that statutory entity. Petitioner can't get over that hurdle for the simple reason that district committees are different from county committees. And because of that fact, he can't meet the high standard for mandamus relief. So turning to the first and primary point, the county letter doesn't satisfy the plain text of the statute. Petitioner himself said all this court has to do is look at 310.5. Well, let's see what that says. Subsection B is clear that when a vacancy arises in the House, the list of 3 names, quote, shall be submitted by the party executive committee of the delegate district in which the vacating member resided. Petitioner's approach to the statute requires the court either to change a key word by substituting the word county for delegate district, or it would ask the court to add a qualifying phrase, something along the lines of the delegate district committee, which means those members of a county committee who reside in the district. But as the questioning pointed out, there's no authority for the point that that in fact is what a delegate district means. So again, petitioner would be asking the court to add terms to the statute that the legislature simply didn't. This court's approach in the Biafor decision doesn't allow that outcome. This court was very clear that this statute in particular must be interpreted according to its plain terms, and there it referred to the 9th senatorial district as the right entities to submit the letter. If you look at page 6 of the petition, even petitioner urges this court not to amend the statute because that would infringe on the legislature's prerogative. The court should take petitioner at his word and give the statute its plain meaning. If we look to the broader context in 319, this also confirms this plain text reading. Petitioner argues that this helps him, but it's difficult to see why, because if we look in particular at subsection F, there the legislature refers to 4 distinct types of executive committees. 2 of them are county committees and delegate district committees. So it's very clear the legislature knew that these were distinct entities and chose to refer to one of them and not the other in the vacancy statute. We have to take this legislature's choice at its word. And here, we have a letter that the governor received that came from the Wayne County Executive Committee. On its face, it did not come from a delegate district. The best argument petitioner has is that the phrase members who reside in District 19 should have somehow put the governor on notice that the letter came from a totally different committee altogether. Now, it's possible that might have been an indirect way of referring to the district delegate committee, but there's no way the governor could have known that from the face of the letter. Importantly, that could have been referring to a totally different set of people altogether. Most of the districts in this state are multi-county. If the governor receives a letter that says members of one county were part of the decision, he might run the risk of disenfranchising voters from other counties in that district as well. So this is why following the plain text of the statute actually ensures that the governor doesn't unintentionally omit any relevant voices from the process. And finally, on this point, petitioner's own conduct confirmed the governor's view that the first letter was invalid. Now, it will not surprise the court there's plenty of dispute between the parties on what actually happened. This court is not a fact-finding body, and the only allegations and affidavits we have at this point are petitioners. So suffice it to say that if my client, and I would imagine the party, were able to submit evidence as well, it would tell a different story. But one thing everyone agrees on is that petitioner had a conversation with governor's counsel, which raised concerns with the first letter. Petitioner doesn't allege that he tried to clear up any confusion by that point by saying, no, when I said members who reside in the district, that was me saying delegate district committee. There's no allegations he tried to clear that up. And then in the days afterward, he acted in a way that further confirmed that the first letter was invalid. He participated in the state party's process, and he signed his name to a letter. Now, of course, he alleges that he signed a letter without knowing what names would be added afterwards. Again, we don't know the facts at this point, and again, my client would dispute his account. But even if we were to take that at face value, at best that means that petitioner may have engaged in an unwise decision of signing his name to a letter and then letting someone add the names after the fact. But if I sign a blank check and give it to someone, and then I'm frustrated later by the amount that's filled in, I don't have a claim against the bank to say they acted improperly when they cashed it. And that's the circumstance we have here. There's no reason the governor would have known that the letter that he received from the proper District 19 delegate committee was inappropriate. So what the governor did was he received a first letter that was facially invalid, and then he acted on a second letter that came from the entity that is specifically described in the statute. There was every indication it complied with the statute as well as petitioner's own conduct. Finally, briefly, if there's any question about the validity of that second letter, that's legally irrelevant. Because, as I said at the beginning, the only way petitioner can prevail is if that first county letter is valid. So let's look at the scenarios there. If the first letter is invalid and the second letter is valid, well, that's exactly what the governor argues happened here. Then the governor was within his statutory duty to appoint someone from the second letter within the 5-day period. But if we look at the scenario of both letters potentially being invalid, petitioner would not be entitled to relief he wants, because the statute specifically talks about what happens if a letter isn't received within the 15-day period. Then the governor has discretion to choose any qualified individual from the relevant party. So even if that were the way the court were to approach letter 2, which to be clear it should not, there's no legal authority to say the governor would have had to refer to the 3 names on another invalid letter. The governor would have had the authority to appoint a qualified individual. There's no question that Joshua Booth is qualified to serve in this role. Your Honors, as you are well aware, the session starts tomorrow. It's critically important that the people of District 19 have representation throughout the whole stage of that process. So we ask this court to rule quickly in order to confirm the governor's choice and to allow Delegate Booth to assume his important role in those proceedings.
So my question is, what is your response on behalf of the governor to the letter regarding your contention that the first letter was facially invalid? There were letters provided in the supplemental appendix indicating, as petitioner indicated, a prior course of conduct, for lack of a better word. That's not what he said. I'm saying that. What's your response to that contention? I suspect you might suggest that we are not a fact finder, but I'm nonetheless interested in your response.
I would, Your Honor, and to be clear, you're referring to the 2018 Wood County scenario?
Yes.
Yes. So that
and the Mercer County letters,
of course. Focusing first on the 2018, that's distinguishable factually for a number of ways. First of all, it's not clear that the governor treated that letter as binding either. If you look at the time frame, that letter was submitted on October 23rd, and the appointment was made 7 days later on the 30th. So if the governor treated it as binding, arguably he would have missed the 5-day statutory deadline. So it's more natural to say what happened there was the same thing that happened here. The governor had a letter that came from the wrong entity. He waited the full 15 days for a valid letter. None did, and so he used his 5-day discretionary period and made the appointment on the 30th instead of the 28th. The other critical distinction there is the main question at that time was whose name would be put on the ballot because the deceased delegate was running for re-election. There's a separate statutory process who picks the replacement, and there the county committee does have a role. So that makes sense why the county was at the center of that discussion and why the governor would choose the person who is going to be on the ballot to allow the voters to make a decision there. But finally, I would say on that point, there's no indication that anyone raised any questions with the letter, certainly no second letter that was submitted. And even if this court were to say that that may have been a mistake in applying the law on one point shouldn't be reason to effectively rewrite the statute for every circumstance that comes forward. So no matter how this court views 2010 and 2018, there's no reason to disregard the plain text of the statute in 2021.
Thank you, counsel. The intervener.
Good afternoon, Chief Justice, and may it please the court. My name is Zach Ritchie, and along with my colleague Andrew Roby, we represent the West Virginia Republican Party as an intervener respondent in this case. Your Honor, to succeed in this case, the petitioner must win every argument placed in his path by the governor and the West Virginia Republican Party. But the truth is, he cannot hurdle the first, which is whether the text of Section 310.5 required the governor to pick from his county committee list. And this court need not decide exactly what 310.5 means in every context, just that in this case, it doesn't mean what the petitioner says it does. And I would associate myself, and I won't repeat the arguments made by the Solicitor General, and we'll join all of those arguments. But I would like to point out as the party here that this court should endeavor to avoid allowing itself to be pulled into the middle of an inter-party dispute among competing factions of the same party organization. For over 100 years, this court has emphasized the limited judicial role in refereeing of the courts in refereeing internal party disputes between different political party factions, even if they might seem legal in nature. And I refer to that, I put that in quotes simply to reference disputes about applicability of bylaws, for example, between a state and county committee bylaws. There is a mechanism within the West Virginia Republican Party for dispute resolution, a binding arbitration process. No surprise there. It wasn't invoked here. It wasn't even, the petitioner didn't even try to invoke it here. I understand that we're on a quick time frame, but it wasn't invoked. Granting the petition would require, therefore, this court to expressly set aside a line of cases going back decades, 100 years, and putting this court's jurisprudence at odds with those courts of other states across the country. And I'd like to respond specifically, Your Honors, to some of the comments from my friend Mr. Bryan and emphasize the point of the question asked by the Chief Justice, which is, didn't the petitioner, Mr. Maynard, acquiesce by his conduct in the position that the party now takes, that the governor now takes, in which list was properly submitted to the governor? And my friend couldn't really answer the question because he did acquiesce in that. He didn't raise objections. He didn't raise complaints at the time. He participated in that process and signed his name. Do they raise some question about the timing of when that signature was applied? Yes, I'll grant them that's an argument they raise. But one thing is clear from their affidavits that they do not dispute, which is the three names that were on that letter that made it to the governor were the names that were selected by the Delegate District Committee on the night of January 21. The timing of whether they were put on that letter before or after they make the signatures, it makes no difference. Those were the names selected, and it was from that list that the governor selected Delegate Booth.
Counsel?
Yes, Your Honor.
Under 319B, it clearly relates to if the county is situated in a multi-county state senatorial or delegate district, and it's talking about, again, electing delegate district representatives. What part of 319, which subsection relates to the election of delegate district representation if the district is wholly contained within a county?
I'm sorry, Your Honor, are you asking about a specific sentence or subsection there?
Well, 319B talks about selection of delegate district representation in a multi-county state senatorial or delegate district, crosses a county line.
Yes.
I'm asking you what subsection under 319 sets forth the provisions of electing delegate district representation when the district is wholly contained in one county.
Well, Your Honor, I'm not sure the section does so.
So is there any place in the code that sets forth a procedure for electing these representatives?
I don't believe so, Your Honor. And I think what's important is, first, we don't need to even reach that, because for all the reasons that my friend the Solicitor General said about the statutory language in the legislature knowing the difference between what a county committee is and a delegate district committee, and county committees don't appear in 310.5.
So if I understand what you just said, the code, although in a multi-county situation, it does define how to elect delegate district representation, but it does not prescribe a method. And are you suggesting then it's up to the state party to do so and not the county as suggested by the petitioner here?
Well, I certainly would advocate, Your Honor, that the party's bylaws, and let me back up for a second. Despite what some of the things that the positions taken by my friend Mr. Bryan in reply and here today, the West Virginia Republican Party is a single party. There is a party, the party, and these committees are parts of that party organization. Okay, and so the state's bylaws are the reflection of the various participants in that process, from the counties, from the senatorial district, in making those bylaws. And those bylaws provide, in this case exactly, and what actually happened here, provide that the chair of a county, where the delegate district is entirely contained in the county, the chair of that county committee, he picks the vacancy committee, the delegate district committee, to choose the vacancy. And that's what actually happened here. Mr. Maynard picked the representatives to serve on this committee that met on the night of the 21st. They came up with 3 names. They communicated to the governor, certified by the state chair, the county chair, Mr. Maynard, petitioner himself, and the county secretary. Those are the names the governor picked from. And so in this very case, the process worked as it's required under the code and the party's bylaws in terms of who is involved. And there was no disenfranchisement here. There was no disenfranchisement here because Mr. Maynard picked those members from his county that came up with the names. There's no dispute. There's no dispute in this case that the 3 names they came up with were the product of Mr. Maynard's appointments to that delegate district committee. And so that's an important signifier here. Did the state chair sign it? Sure, but signed it to certify it, to say, yep, those were the names that the delegate district committee picked. Not the names I picked, not the names I approve, but the names I certify. And that's what he did. And that's what the county chair did, and I take him at his word when he signed that. They haven't disputed the authenticity of his signature or the county secretary. So that goes to the other point of acquiescence, Your Honor, that we don't think we should even be here. This should be dismissed because petitioners changed his views on this after acting contrary to them after the fact. Unless there are any questions, Your Honors.
You're hanging, as I see it, you are hanging your hat on a very technical reading of 310.5b, and it says it provides a list of candidates to fill the vacancy shall be submitted by the party executive committee of the delegate district. And your argument is that the executive committee of the delegate district is different from the county executive committee. And when the statute doesn't go any farther, 319 doesn't get into it if it's all in a single county district, then your argument is that the state, the Republican Party bylaws take over and give the guidance on how that delegate district executive committee is to be defined.
Well, I think my initial position, Your Honor, is, as you first said, which is I don't think it's ambiguous because, and we're not working in a vacuum, because of 319 refers to both delegate district committees and county committees. And so the legislature knew these were 2 different concepts. And then when they wrote 310.5, they only selected one of those concepts. So our first position is that it's unambiguous, and it's not, we know it's not county chairs is what they refer to in 310.5. So the petition should fail for that reason. But to the extent it is ambiguous, or this court determines it's ambiguous, we look to how that phrase, how that term is used in practice. And it's used in both political parties' bylaws as a term different from a county. The state, in subsection A, as my friend described, the legislature delegated this power to make nominations to political parties. For better or worse, that's what they decided. And so to the extent they've set forth any further specification on how that's supposed to happen, the parties fill in the gaps. And that's what the bylaws did here. That's what happened here. And that's how we ended up with Delegate Booth in this seat and filling the vacancy.
Any additional questions?
I have one quick question, and that is, we're on a bit of an expedited briefing schedule here, and we've had an amicus brief, I believe, that was filed yesterday, raising issues of the Open Meetings Act not being complied with. What, if any, significance do you believe that allegation is in the amicus?
I'm going to be honest with you, Your Honor. I haven't fully engaged with that issue and had an opportunity to discuss that with my client. So I'm unfortunately not prepared to address that today. My sense is that it doesn't apply to the party organizations, but that, of course, that issue hasn't been briefed. And if the court is interested in looking at that issue, I would respectfully request an opportunity to brief it.
And to be fair, I believe that brief was just filed yesterday, so I appreciate your candor.
Thank you, counsel. If the petitioner, you have 2 minutes to respond, and you're welcome to do so.
All right, I have just a couple minutes to hit a lot of points. I have responses to all of that, but perhaps the most important thing is the statement by Ms. C that it's, quote, critically important that District 19 has representation. Well, that's the whole reason that we filed this case. That's why we're here today. The fact is that the District 19 committee members, and there's only 4 of them, all participated in that first list. The man ultimately chosen by the governor was not on that list, was not chosen by those 4 members. That's what it comes down to. That's why we have local people who know the candidates, who know the people who've been involved in party politics that are making these decisions.
How was the makeup of the committees different? I mean, the members of the committee in both instances had to be from Delegate District 19. So how was the makeup of those committees different?
That's a great question, Justice Hutchison. There were 4 District 19 committee members. Now, there are 5 magisterial districts in District 19. There were vacancies that had not been filled. Therefore, there were 4. That was the total number of District 19 committee members. All of them convened to make the first set of choices. At the second meeting, that was called by the acting chair of the state GOP, and that was run by the acting chair of the state GOP, there were only 2 of those same committee members there, one of whom was apparently contacted by one of the state or national party members and asked them to be at this second meeting. So there was, the second meeting had only 50% of the committee members who were at the first. And that brings me to just a really important point here, and that is, I think they've tried to muddy the waters here on, well, what is District 19 committee? It's just this, no one seems to know what it is. Well, there's no dispute. There are only 4 District 19 committee members. There's no dispute as to who those individuals are. They were the 4 individuals that voted on that first list. And they're elected or appointed out of Wayne County at the local level. And what are they members of? What organization are they members of? They're not members of the State Executive Committee. They're not members of the State Executive Committee. In fact, we can look at the state's bylaws and...
Well, that doesn't answer my question. My question is, how were the makeups of the panels different? Were both panels comprised of District 19 committee members?
the first meeting was comprised of all 4 District 19 members who are members of the Wayne County Republican Executive Committee.
Who was on the second?
There were 2 of those 4 that were at the second.
How many total members were on the second panel?
Only 2. And in fact, if you look at the Wayne County bylaws, and surprise, Wayne County is a separate political party executive committee, completely separate and independent, not a subcommittee. They have their own bylaws, and their bylaws require 3 for a quorum. Therefore, 2, the only 2 members that were at that second meeting did not consist of a quorum under Wayne County's own bylaws. So one thing we know for sure, despite the confusion of who the District 19 committee consists of, we know it's not the state executive committee. We know it's not the state GOP. You can look at their bylaws. It's, what is it, Article 2, Section 1. It says this is the body of the state Republican Party Executive Committee. Nowhere in there does it list any delegate District 19 members. They're not even a member of the state executive party. They are only members of the county, of Wayne County Republican Executive Committee. That's why, Justice Walker, you brought up the prior times that this happened. I think perhaps the most important one to look at is 2010, when this same acting chair, Roman Stauffer, who was involved in this matter, he was previously in 2010 the chairman of the Mercer County Republican Executive Committee, and in our supplemental appendix to the reply brief, I included every document I could find pertaining to the 2 appointments that then County Chair Stauffer made or presided over in 2010, one of which was Bill Cole. And you can look at the correspondence, setting those up, the meetings, the minutes of the meetings, and the press releases. And it clearly states that it was the Mercer County Republican Executive Committee, headed by and presided over by Chair Stauffer, then, who sent the list of 3 to then Governor Manchin. And if you look at the...
Council, your time has expired, and we have reviewed the supplemental material very carefully. If you would like to conclude, this has been a very well-argued and brief case on an expedited manner, but I appreciate it.
Can I ask one question just on what you just said real quickly? Yes. In the 2010 situation, was the bylaw section that's been cited here, the state committee bylaw, was that in effect at that point? The provision that says that Article 6, Section 4 of Article 6, was that in effect at the time in 2010, or was that subsequent to that?
No, and that's a great question, Justice Armstead. My understanding is that the state GOP amended their bylaws in the summer of 2020 to purportedly give themselves control over the nomination for legislative vacancies. That was not found anywhere in the state GOP bylaws prior to the summer of 2020, nor is it currently found in the state Democrat Party bylaws, because to do so would be very problematic, because that's essentially altering West Virginia Code 310.5, and that's exactly what you're not allowed to do under, 3111. It says, this is part of our body of election law that says no state executive committee of either party, of any party, can use its own internal bylaws to change existing West Virginia code. And that's what they've attempted to do, is they use this 1964 case, State Ex Rel Zagula, and they actually put it in their bylaws in a footnote, and it says that, look, this 1964 case says that we can do whatever we want to the local and legislative district committees, and the court's not going to mess with it because that's an intra-party dispute. And that's what they've claimed here. And that's not an intra-party dispute. They're trying to change state law. The Zagula case had to do with the same county executive committee. I think it was Hancock County. It involved a guy named John Bryan, who they were suing to get John Bryan off of that ballot, or maybe it was vice versa. But it had to do with a new board basically changing the result of the choice of the last board from the same committee. And the court expressly made a distinction that this is not involving 2 different committees. And that's the big distinction here. This is involving not an intra-party dispute. This is one political party committee that is elected by Wayne County voters being engaged in a power grab or attempted control by the state executive committee that has no direct connection to the local Wayne County voters. And that, I would argue, to conclude my arguments here today, is the whole point, that they ended up not with somebody that they voted for or necessarily even knew that's now sitting in the seat, but they ended up with somebody that, according to the records, donated to Governor Justice when he ran for office in 2016 as a Democrat.
I think we understand your point.
Thank you.
In your argument, again, this case was very well argued and briefed. On an expedited matter, it will be submitted.